Okay. Okay. The Rules Committee will come to order. Let me just say this on my, I just wanted attention. It's a cry for help. I had a small, but, relative, not too painful procedure, no big deal, but as I'm looking at the schedule here today, this will be much more painful. So I'm sorry to, but anyway, today we're meeting on three measures. The first is H.R. 5314, Protecting Our Democracy Act. Unfortunately, some of America's democratic institutions that were always thought to be sacrosanct have proven to be more fragile than many has ever imagined. We have seen the threats to our free and fair elections come from a president sitting in the Oval Office and from foreign adversaries alike. This is perhaps the most urgent matter that we face today. Because whether you care about women's rights, climate change, economic justice, I can go on and on and on, who we elect matters. And having faith in our democratic institutions, whether a Democrat or a Republican is president, matters. As Benjamin Franklin walked out of the Constitutional Convention, he said the founders had just created a republic, if you can keep it. This bill is about helping us keep our republic. It's not about Donald Trump. He may have exposed the fault lines in our democratic system, but he did not create them. This bill is about looking ahead and repairing them for generations to come. It is a comprehensive proposal that will restore our government systems of checks and balances, strengthen accountability and transparency, and protect America's elections from foreign interference. And it includes ideas that Democrats and Republicans have supported in the past. Second, we are also considering the National Defense Authorization Act, which is the product of extensive bipartisan and bicameral negotiations. The House passed its bill back in September, and I'm pleased to see that we are close to finally sending this on to the President and for his signature. Third, we are considering S-610 to help us take care of some of our most pressing business. That includes setting up a process in the Senate to raise the debt ceiling, clearing the pay-go scorecard, and preventing doctors from facing looming Medicare reimbursement cuts. We heard Dr. Burgess talk about the urgency of that matter just a few days ago. Democrats and Republicans have done all three of these things in a bipartisan way many times in the past, no matter who controlled Congress, and we should be able to come together and get them done now. Lastly, before I turn to our ranking member, I want to send our condolences to Congresswoman Torres on the passing of her dad. Norma, if you are watching, I know that we're all thinking of you and your family during this difficult time. And okay. So with that, I'm going to turn this over to the ranking member.
Thank you very much, Mr. Chairman. Before I go to my formal remarks, I want to associate myself with your very kind remarks and extend my sympathies to our friend from California in this time. It's difficult for anyone when you lose your dad. And again, our thoughts and prayers are very much with our friend, and we hope she's back here soon. But hope she also takes whatever time she needs to look after her family, as I'm sure she will, and we all support her this difficult moment. And I want to tell you, Mr. Chairman, we sympathize with you too. And we're not surprised that you're here, no matter what, discharging your duties, and but we wish you a speedy recovery. Our hearing today, Mr. Chairman, covers three items. The first item I'll discuss is happily a bipartisan item. This is the bicameral agreement on the National Defense Authorization Act for fiscal year 2022. Though it may have been a long road to get to this point, I'm encouraged that we are soon poised to enact the NDAA for the 61st consecutive years. Today's bill is a clear winner for our national defense and for the American people. Earlier this Congress, President Biden proposed a defense budget that was in no way adequate to meet our defense needs. Chronic underfunding of the American military was a hallmark of the Obama-Biden administration, and the President's budget revealed a planned return to that sorry state of affairs. Fortunately, a bipartisan coalition of members in both the House and the Senate rejected that approach, ensuring adequate funding for our national defense needs. The bill before us is a remarkable accomplishment, one that reflects what Congress can do when we work together across the aisle. The bill fully funds our defense needs for the coming year. It provides a pay raise for our troops, funds additional ships for the Navy, and ensures the warfighters of tomorrow will have the weapons and assets they need to succeed on the battlefield. It also provides much-needed oversight of President Biden's bungled withdrawal from Afghanistan, ensuring that the American people will receive the answers they deserve about the decisions that were made and the resulting failures of leadership. I want to commend the leadership of Chairman Smith and Ranking Member Rogers. The way they've conducted this process has been a model for other committees to hopefully follow. I appreciate the dedication they both exhibited and the results it produced. Our second item is the House Amendment to S-610, which addresses Medicare sequestration. While most members on both sides of the aisle would agree that a resolution of this problem is necessary, I feel today's bill is a missed opportunity for bipartisanship. Instead of a clean bipartisan deal, we have a bill which includes provisions addressing the debt ceiling and the delaying of pay-go cuts from the Democrats' partisan reconciliation bill earlier this year into the future. It's disappointing that Democratic leadership in the House and the Senate waited until this point to address the debt ceiling. Since the summer, Republicans have made it very clear that if the majority continues to choose to spend large amounts of taxpayer dollars through partisan reconciliation bills, then the majority should also use that power to increase the debt limit on their own through reconciliation. Their failure to do so has placed the House in an awful and awkward position, resulting in today's unfortunate bill. Finally, our third item is H.R. 5314, the majority's calling the Protecting Our Democracy Act. The bill is a package of purported reforms relating to presidential power, accountability and transparency, and foreign interference in elections. Parts of this bill have previously passed the House as part of the majority's previous purported reform packages, including H.R. 1 and H.R. 2662. I have three major areas of concern with this package. First, the bill is not a serious attempt at passing a real government reform package. Instead, it amounts to an attempt to change the law to address every single Democratic complaint about the previous administration. At a time when the American people are rightly concerned about inflation and the weak economy, the majority is once again wasting its time by talking about the former president. I can think of countless other ways we could be spending our time that would be more productive and that would deliver better results for our constituents. Second, the bill is largely duplicative of other bills that have previously passed the House. Not content with having previously passed H.R. 1, a bill designed to protect Democratic incumbents, the majority is now seeking to pass some of the same provisions as part of the new package. This is a complete waste of the House's time. Third, there are some provisions in this bill that have general bipartisan support and that could be enacted into law, but their inclusion in this partisan package shows that the majority is not serious about enacting these reforms. If they were, they would allow these provisions to come to the floor separately as part of a standalone bipartisan reform package. Today's hearing is sadly yet another instance of the majority choosing to score political points instead of choosing to govern. As I've said many times, we can do better than this, Mr. Chairman, and I think we must do better. With that, I yield back.
Thank you very much, and the ranking member yields back his time. Thank you for his opening. I'd like to welcome our witnesses to provide testimony on H.R. 5314, the Protecting Our Democracy Act. Chairwoman Maloney, Ranking Member Comer, Chairman Nadler, Ranking Member Jordan, we're delighted that you are here. I now recognize the gentleman from New York, Chairwoman Maloney.
Chairman McGovern, Ranking Member Cole, and members of the committee, thank you for the opportunity to speak to you today on behalf of the Committee on Oversight and Reform. I am here today to testify in strong support of H.R. 5314, the Protecting Our Democracy Act. This bill is a sweeping package of reforms, many of which have been supported by both Democrats and Republicans in the past, that will restore the government system of checks and balances and strengthen accountability and transparency. The bill would take bold actions to prevent misuse of federal funds, strengthen protections for inspectors general and federal whistleblowers, prevent foreign interference in elections, and ensure that no person, no president is above the law. The Committee on Oversight and Reform has jurisdiction over multiple titles in this landmark legislation. One of those provisions, Title VII, is based on the Inspector General Independence Act, which I introduced last year with Majority Leader Steny Hoyer and several other members of the Oversight Committee. This title would strengthen the independence of inspectors general by protecting them from being fired for doing their jobs. Under this title, an IG could not be removed for a documented cause they could only be removed for cause and based on a defined list of nonpartisan reasons such as malfeasance, knowing violation of the law, or gross mismanagement. This reform also passed the House in June as part of a larger package of IG reforms. This title would bolster IG independence by requiring notification to Congress before an IG is placed on non-duty status. This bipartisan reform has passed the House several times in the Inspector General Protection Act, a bipartisan bill introduced by Representative Ted Lieu and Jody Heiss, ranking member of the House Oversight Government Operations Subcommittee. Title VIII is based on the bipartisan Whistleblower Protection Improvement Act, which I introduced in May and which would strengthen protections for federal whistleblowers. This title would prohibit agencies from launching retaliatory investigations against employees who blow the whistle and would limit the public disclosure of a whistleblower's identity. It makes clear that no federal employee, including the President or Vice President of the United States, may interfere or retaliate against a whistleblower for sharing important information with Congress. Title VIII would also provide federal whistleblowers with faster legal recourse for retaliation claims and would allow whistleblowers to have their claims tried before a jury in federal district court. The Oversight Committee also has jurisdiction over Title IX, which is based on Representative Katie Porter's Accountability for Acting Officials Act. This title would clarify and strengthen requirements on who can serve as an acting official when a Senate-confirmed position is vacant. The Federal Vacancy Reform Act of 1998 has many provisions that are unclear, creating loopholes that are ripe for abuse. Title IX would shorten the amount of time that top officials can serve in an acting capacity to 120 days, down from the current 210 days, while providing additional time when the Senate is considering a nomination. In addition, the bill would limit who can serve as an acting official. It would require that a, quote, first assistant, which generally refers to the deputy at an agency or office, was in their position prior to the vacancy in order to serve as an acting official. The bill would also require acting officials to testify regularly before Congress, require faster reporting to Congress when a vacancy arises, and close loopholes that allow the president to appoint acting officials without any experience in the agencies they lead. Title X would strengthen the Hatch Act, which is intended to protect the government from political interference. Last month, the Independent Office of Special Counsel issued a report that found that at least 13 senior officials in the last administration violated the Hatch Act when they used their official positions to bolster a re-election campaign of the former president. OSC found that these senior officials, including top White House aides such as Mark Meadows and Jared Kushner, and cabinet members such as Mike Pompeo, engaged in a pattern of terrible violations of this crucial law. OSC found that when confronted with these violations, the Trump administration defended them and failed to even hold a single person accountable. This title, which is based on the Hatch Act, Accountability Act, would strengthen enforcement and penalties for political appointees who violate the Hatch Act. Title XI would promote efficient presidential transitions. After the 2020 presidential election, the head of the General Services Administration refused to grant the Biden-Harris transition team access to critical services, space, and information specified in the Presidential Transition Act, and to millions of dollars in funding that Congress had appropriated for transition activities under the Act. This title promotes orderly presidential transitions by requiring that if the Administrator of General Services does not ascertain a winner in a presidential election within 5 days of the election, then each eligible presidential candidate and vice presidential candidate shall be treated as a winner until a winner is confirmed. This is important for national security, that all candidates have access to national security information during transition periods. I look forward to answering your questions. This comprehensive legislation also includes many other important provisions in the jurisdiction of other committees, including some very important provisions Chairman Nadler will address along with the ranking member, such as restoring our systems of checks and balances by strengthening Congress's ability to enforce subpoenas. I yield back the balance of my time, and I thank the committee for the opportunity to speak before you today. I yield back.
Gentlelady yields back. Thank you for your testimony. The gentleman from Kentucky, Mr. Comer, is now recognized for his testimony.
Well, thank you, Mr. Chairman. By bringing the Protecting Democracy Act to the floor this week, the House is making it clear to the American people that they are not their priority. Partisan politics is the priority of Democrat House leadership. We're not focused on the pressing economic, public safety, and national security needs of the nation. We're focused on pushing through a Frankenstein bill thrown together without substantive committee involvement. Over a dozen unique bills are stitched together in this partisan package. Basically, H.R. 5314 appears to be an effort by the House Democrat leadership to relive its glory days from the last Congress with its Trump-obsessed investigations. Mr. Chairman, the lack of regular order and due diligence by the bill's drafters should be unacceptable to anyone sitting on this committee, regardless of their political party. That's what the Rules Committee's for. There are massive portions of this bill that are entirely new to the 9 committees of jurisdiction. It's unclear if this legislative package was properly vetted by the key executive branch entities impacted by the requirements, if all the parts work together, and how outside special interest groups may have been involved. Some portions even appear to be in direct conflict with the Constitution established Supreme Court precedents. For example, Title III's legislative attempt to define an emolument will likely preclude most successful business leaders from running for president if they have conducted any business outside the United States. That'd probably affect Hunter Biden if he wanted to run for president, Mr. Jordan. The Supreme Court holds a different, more narrow interpretation of the constitutional definition that would then be in conflict with this bill, should it be enacted. This section's authors seem to believe they can simply rewrite the Constitution's definition of emolument to protect career politicians. Unfortunately, like this provision, much of the bill offers reforms for problems that don't exist, while our country is actually facing real problems. As we consider this legislation, we're in the midst of the holiday season, during which Americans are paying more at the pump and in grocery stores. Businesses are struggling to fill jobs and get supplies on time. The border has devolved into a humanitarian crisis and national security threat, and our allies look at our withdrawal from Afghanistan with horror and our enemies with glee. Meanwhile, my Democrat colleagues are prioritizing a bill that erodes the powers of a duly elected president and bolsters an unelected bureaucracy. We should be focusing our legislative efforts on helping the American people. This bill is not it. But if my Democrat colleagues are serious about advancing such a substantial legislative overhaul of executive branch powers, they should consider the various provisions within this package under regular order. I want to encourage all my colleagues here, let's get back to doing what the American people elected us to do, to represent their interests now, not relitigate the past through hyper-partisan, reckless legislation. We're the people's house. We need to get back to working for the people. Mr. Chairman, I yield back.
Gentleman yields back. The chair now recognizes the chairman of the committee, Mr. Nadler, for his testimony.
Well, thank you, Chairman McGovern, Ranking Member Cole, members of the committee. Thank you for inviting me to testify about the Protecting Our Democracy Act. Transparency and accountability are the bedrock of our democratic system. They are the essential guardrails that protect against unchecked executive power. Unfortunately, recent experience has uncovered weaknesses that point to the desperate need for reform in these areas. The Trump administration in particular exposed certain vulnerabilities in the fabric of our democracy by engaging in conduct that was once unthinkable. The Judiciary Committee witnessed several abuses that we respond to in this legislation. Although many of these reforms were informed by our experience with the prior administration, they are pointedly not anti-Trump measures. Rather, they are forward-looking. They protect against abuses by any president or any party in the future. Importantly, many of them are also based on proposals that have bipartisan support. For example, a vital provision to strengthen Congress's ability to enforce its subpoenas is based on legislation originally introduced by Congressman Issa that previously passed the House by voice vote. Although the executive branch of Congress can and should usually resolve oversight disputes through a process of good faith negotiation and compromise, there are times when Congress must sue to enforce its constitutional prerogatives in court. But today, any administration intent on stonewalling Congress can be rewarded by a cumbersome court process that enables the administration simply to run out the clock and to avoid any meaningful oversight. This is an invitation to unchecked executive power and abuse. That is why the Protecting Our Democracy Act incorporates legislation by Congresswoman Madeline Dean, which provides an expedited, streamlined process for the House and Senate to enforce their subpoenas in the courts, if necessary, to ensure that we can conduct proper oversight. Another important provision would address abuses of the clemency power. Throughout history, presidents of both parties have issued controversial pardons that deserved scrutiny by Congress. That is why this legislation includes Chairman Schiff's provision to require the Department of Justice to disclose materials to Congress related to pardons or commutations that might be done for potentially self-serving reasons or for an offense involving contempt of Congress or obstruction of Congress. It also reaffirms that abuses of the clemency power can form the basis of a bribery scheme under the federal anti-bribery statute, and that self-pardons are prohibited, since no man can be his own judge. This bill would also ensure that presidents and vice presidents can be held accountable for criminal conduct, just like every other American. Justice Department policy holds that a sitting president cannot be prosecuted, no matter how serious the crimes he or she may have committed. And when the president leaves office, particularly if they have served 2 terms, in many cases, the statute of limitations will have run on their crimes, and they will be immune from prosecution. In effect, this policy has turned the presidency into a get-out-of-jail-free card. That is why the bill includes my legislation, the No President is Above the Law Act, which would toll the statute of limitations while a president or vice president is in office, so that prosecutors could consider prosecutions after their term is over. The bill also makes clear, however, that this provision does not preclude their indictment or prosecution while they were in office. It simply allows for the possibility that prosecution may be delayed. The final provision I want to highlight would address improper communications between the White House and the Department of Justice. In the prior administration, we witnessed blatant interference by the White House pending criminal cases at the DOJ on matters that directly implicate the president, such as the Roger Stone sentencing, the Michael Flynn prosecution, and the Russia investigation. That's why this bill includes Chairman Jeffries' legislation to require that the Attorney General maintain a log of certain contacts with the White House for review by the DOJ's Inspector General. The Inspector General would then report to Congress if there are any communications that may be inappropriate from a law enforcement perspective or that raises concerns about improper political interference. When the nation's founders wrote the Constitution, after having just fought a war against the tyrant, they stood fast to a key principle, that the executive must not be a king and must instead be accountable to Congress, to the people, and ultimately to the rule of law. It is vital that we reassert this important principle. The Protecting Our Democracy Act would restore these and other checks and balances that are so fundamental to our democracy. I want to thank Chairman Schiff and all the other members who contributed to this important legislation. Thank you again for inviting me to testify, and I would be happy to answer any questions.
Thank you, Chairman Nadler. The gentleman from Ohio, Mr. Jordan, is now recognized for his testimony.
Thank you, Mr. Chairman. I too want to extend our sympathies to Ms. Torres and her family. Mr. Chairman, this legislation before us is yet another example of Democrats' obsession with President Trump. The sponsor of this bill spent years totally misleading the nation. Remember when he said he had proof of Russian collusion? Said, I have more than circumstantial evidence of collusion. The Mueller investigation found no such proof. The Justice Department found no such proof. The Democrats' failed impeachment investigations found no such proof and the reason they found nothing is because it was never true in the first place. That's right. The sponsor of this bill spent years misleading our country about President Trump and fear-mongering in the hopes of sowing enough division in our nation to help Democrats with their electoral goals. Now, with President Biden in office, Congressman Schiff and the Democrats want us to believe that their concerns are sincere, and these laws should apply regardless of who occupies the White House. But come on. Mr. Nadler just said it's not about Trump. Democrats, I just don't buy that. Democrats believe that President Trump will run again, and with President Biden's approval ratings at 38%, probably get elected again in 2024, and legislation like this will permit them to hamstring him with another truckload of bogus investigations. Maybe, just maybe, instead of obsessing over President Trump, the Democrats could pass some legislation that tackles the failures made by the current occupant of the White House. Everyone knows the American people are worse off today under President Biden and congressional Democrats than they were under President Trump. Inflation keeps rising. The latest jobs report was bleak. There's a crime epidemic ravaging our cities, and the southern border is beyond broken. President Biden let down our service members and allies in Afghanistan. He has his Attorney General and Justice Department as we speak, using federal counterterrorism resources to target parents who are sticking up for their kids at school board meetings. The Biden administration is a disaster. It's unfortunate we have to say that, but it's true. You know it, I know it, and most importantly, the American people know it. This bill is just an excuse for Congressman Schiff and the Democrats to keep peddling debunked conspiracy theories about President Trump. We should be on the floor talking about how to fix the border, how to make sure cities around the country don't jeopardize their public safety any more than they already have, or how to make sure Americans actually get Christmas presents on time this year. That's what the American people care about. That's what I hear about from the great people that I get the privilege of representing in the 4th District of Ohio. But even setting aside the Democrats' partisan motivations, much of this bill is just plain bad policy. Rather than promote oversight of the executive branch, this legislation would make it easier for attacks on Republicans from unelected and unaccountable bureaucracy. Of course, Republicans are in favor of responsible, legitimate oversight, and there may be a couple of ideas in this bill that we could support. But instead of working with us in good faith, Democrats jam these ideas into one big messaging bill without any hearings in the Judiciary Committee. And Mr. Chairman, if we're going to make big changes like this to laws related to the separation of powers in our country, then every single piece of this bill must and should go through regular order. Democrats want to make fundamental changes to government oversight and not hold hearings on every aspect of the legislation, where we could hear from experts about how these provisions would work in practice and what sort of unintended consequences might occur. If they were serious about this efforts, they would have tried to work with us. If they were serious about this effort, the Democrats would not have been afraid to have hearings and markups on the very ideas that are in this legislation. They didn't either. Mr. Chairman, I urge opposition to the legislation. Yield back.
Gentleman yields back. I guess I'll recognize myself for a couple of comments and then yield to Mr. Cole. So I guess, Ms. Maloney, in your opening, really this is about the rule of law and the fact that the ex-president and a number of his employees just thumbed their nose at the rule of law. Would you like to expand on that at all?
Yes, I would, Mr. Perlmutter. That is the truth. The Protecting Our Democracy Act includes many reforms, and I really want to object to the statements by my good friends and colleagues on the opposite side of the aisle who say this is all about Mr. Trump. Mr. Trump is no longer president. This bill is about Mr. Biden and other future presidents, whoever they may be, Republican or Democrat, holding them accountable. That's what this bill is about. And it will prevent executive branch abuses in the future and bring more transparency and accountability. We should want to strengthen the value of a congressional oversight, not weaken it. And this addresses many ways in which prior presidents have abused authority going forward. But this is not about the past, it's about the future. It pertains to, the only president it pertains to right now is Mr. Biden, because he is president. And I think everybody would like to hold him accountable to the law. That's what this bill does.
Thank you. And I just remind my friend from Ohio that since Donald Trump lost the race back last November, the stock market's up almost $13.5 trillion. 6 million jobs have been added. The GDP is up by 5%. And obviously there are shortages of different things that really resulted from COVID. You know, a year and a half ago, you couldn't get toilet paper at any price. You couldn't get Purell. You couldn't get a ventilator. The United States was paying fortune for ventilators. So COVID is going to interrupt this economy for some time to come. I'd say to my friend, Mr. Comer, gas prices in Colorado are down. They're lower than they were under George Bush and have been for some time. And so, you know, economy begins to take off and everybody just wants to talk it down. But we had the fewest unemployment claims in the last 50 years last month. So
We respond.
you'll get a chance with Mr. Cole. I'll let you respond. You and I, we end up having conversations
No,
here.
I would just ask you two questions. If it's so great, why are we at the 31-year high inflation rate, and why is the president's approval rating at 38% and the vice president's approval rating at 28%? I would trust the American people more than the statements you just made.
Well, I trust those numbers, and you know, I guess what we've got is we've got an ex-president who continues to flail about, and this bill is designed to take care of some of the inadequacies we saw at the end of that administration. I'm a co-sponsor of this bill, and I just thank Ms. Maloney and Mr. Nadler for bringing it forward, and I'll yield to the gentleman from Oklahoma.
Thank you very much, Mr. Chairman. I just have a couple quick questions. First, to my friend, Mr. Comer, are there, of the items in the package that your committee has jurisdiction over, there are areas that you could have found bipartisan agreement on?
Sure, absolutely. I mean, there's, 13 or so bills cobbled together in this. There are a couple of bills that I think that we could come to terms on. Obviously, with respect to strengthening Inspector General, that's a very important role for the Oversight Committee to have good, credible Inspector General. It's just how they go about it and limiting the president's ability to terminate an Inspector General for poor performance. So, for example, with the Election Assistance Commission, we, the Republicans on the Oversight Committee, sounded the alarm a long time ago about concerns we had with dollars that states were getting to spend on election education efforts. And sure enough, the GO did an audit and found that over 20% of that money was unaccounted for. We called on the IG to do an audit 6 months ago, and they didn't even know what an audit was. So we called on the Inspector General to be terminated, to resign. They finally resigned. But, you've got to, a president has to have the ability to be able to replace incompetent personnel, and if they don't meet one of their titles, that's not it. Another thing, Mr. Cole, I've always been, I'll speak for myself and not the Republican conference, I've always been a proponent for politicians disclosing their tax returns. And I think that that's something that would be good. to require presidential candidates, and as well as their children. That would help us out a lot with our investigation with Hunter Biden if we had his tax returns, and that would answer a lot of questions with our concerns of national security risk. So I think there are plenty of areas where we could come to terms and have bipartisan support, but not the way this bill's put together, and certainly not by avoiding all rules of regular order.
Well, and did the Democratic majority make any meaningful attempt to work with you through the legislative process where you could identify the things you could work together on, move those, and then obviously they're certainly free to pursue their agenda in the other areas?
Unfortunately, no.
Okay, I actually have the same questions for you, Representative Jordan. Again, are there items in this package that your areas of jurisdiction that you work on that you think we could have come to agreement on and moved?
Yeah, I think, Mr. Ranking Member, yes, there are. I'll give you an example. It would be nice if when we ask for information from some of these agencies, whether we ask for it or whether we're trying to compel them via subpoena, that they would actually get the information to us instead of typically, you get the runaround. And I would just point out, as Mr. Nader said in his opening statement, he said that we need to be able to get communications between the White House and the DOJ. And the chairman of the Oversight Committee said this bill is not about President Trump, even though the chairman just said it was. She said it's about Biden. Well, if that's the case, then I would love, frankly, to get the communications that we know took place between the White House and the School Boards Association before they sent the letter that prompted the memo where they're now targeting parents. And I would love to know what the White House is saying, as Mr. Comer just pointed out on another issue, what the White House has said to Attorney General Garland regarding that issue. And it would be nice if it's really as the chairman of the respective committees have said, if they would join us in the 8 different letters we have sent to Director Wray, Attorney General Garland, and the White House asking for that information. If that's really what they want, I would like for them to join us in this important issue.
Again, same question I asked to Mr. Comer. Was there any effort to, again, reach out? Okay, look, we understand we have partisan differences here. Here's areas where we could work together, have a product. You can still pursue the other issues you want to, but why don't we at least salvage portions of this bill that we could work together, and bipartisan product coming out of here would have a lot better chance in the United States Senate of making it through as opposed to this bill, in my opinion. Was that attempt ever made?
The only time we had any hearings whatsoever on items contained in this overall package were in the last Congress. And this is a different Congress with new members. There was no willingness to reach out and work with this, as the ranking member suggested.
Again, I regret that because I think there's some things we could have got done, but with that, Mr. Chairman, I'll yield back.
Gentleman from Oklahoma yields back. The gentlelady from Pennsylvania, Ms. Scanlon, is recognized for her questions.
Thank you, and I am a co-sponsor and big proponent of this bill. I think it's long past time that we codify some of what we're heretofore the norms that govern conduct by our elected leaders when we aspired to the highest ethical standards as opposed to the bottom dwelling or just avoiding prosecution. So I really welcome this bill going forward. Particularly interested in some of the provisions having to do with foreign donations to our political actors in our world and to inaugural funds. I have a bill on that myself. Can you speak to that at all, Representative Maloney?
That was not under the jurisdiction of my committee. My committee authored the Whistleblower Protection Act, which was bipartisan, and other times, and the IG Strengthening Act, which was also bipartisan. But that particular area is covered by the House Administration Committee on Foreign Influence.
Okay. Can you speak a little bit to the Inspector General's Act, because that has been so important?
I would say the IGs are among the most important aspects of our government. They act to keep our government honest. And when they initiate investigations against alleged corruption or are looking into what they believe might be a mishandling of the law, too often they have been sidelined, fired, removed from their positions, and replaced with temporary acting officials who in many cases don't have any experience. And so the committee said that you had to have for cause to remove an inspector general. and state why you are removing them. You can't come in and say, you're doing an investigation against the Department of Defense, you are now fired. They would have to say why they are removing the Inspector General. And I think protecting the integrity of the Inspector Generals and their ability to do their jobs is absolutely fundamental to our form of government. Not only did they remove them willy-nilly, but they also then replaced them with unqualified political appointees instead of professionals. And our bill says that professionals that are part of the IG staff, that are the deputy, that have worked in these areas, if you're removing someone, then you move in someone who has some experience. And you don't load up all your IGs with temporary acting officials who have a time limit, who will be fired willy-nilly, have no protections from civil service or anything else. They're political appointees largely. And so this is really something that we should join hands in working together, because if the IGs can't do their job, they are really the fundamental line that checks government, that investigates. When a whistleblower brings something to them, it's their responsibility, if given reasonable evidence, to initiate an investigation. And too often they are fired, removed, sidelined, kicked out of their position for just doing their job. And I yield back.
Yeah, we certainly saw a lot of that under the last administration, multiple IGs who were forced out when they were critical of the administration. And, Mr. Jordan was just complaining about the difficulty in getting information from an administration that might not be from the same party, but certainly when the shoe was on the other foot during the last administration and we couldn't get responses from the Trump administration to many of our inquiries, it was the inspectors general who came forward with information of wrongdoing. And without them, it was very difficult for Congress to exercise its duty to act as a check and balance upon a rogue administration. Is Mr. Nadler still on the line? Yes. Mr. Nadler, could you speak to the pardons portion of the bill? Because we've certainly heard over the last several administrations, from time to time, questions arise about the propriety of pardons that are offered. Can you talk about how that section of the bill would address concerns?
Sure. The pardons, and let me, before I answer, simply comment on what Mr. Jordan was saying. We marked up in the Judiciary Committee, we marked up the abuse of the Power Prevention Act and the No President is Above the Law Act in the last Congress. We held a hearing on the subpoena bill in this Congress. So you should not be heard to say that the committee didn't give adequate consideration. But getting back to the pardons, there's been a problem with pardons, obviously, when a president, and again, remember, this applies to future presidents, just as during the Nixon administration, the misconduct in that administration showed problems, and Congress passed the Watergate reforms afterwards to apply to future administrations. So some of the problems we've seen in the Trump administration has informed us with respect to problems that we have to address for future administrations, which is why this is not a get Trump thing. Although he educated us, some of the actions educated us as to necessity for future future actions. Now, the Chairman Schiff's provision with respect to pardons would require the Department of Justice to disclose materials to Congress related to pardons or commutations that might be done for potentially self-serving reasons, or for an offense involving contempt of Congress or obstruction of Congress. It also reaffirms that abuse of the clemency power can form the basis of a bribery scheme under the federal anti-bribery statute, and that self-pardons are prohibited. Because, as I said before, no man can be a judge in his own cause.
Thank you. And certainly the Rules Committee is very familiar with the issue of a need to clarify the path to enforce congressional subpoenas, because that was the discussion under our last meeting. So I think, and my constituents think, it's important to clarify that path so that Congress can have prompt enforcement of its subpoenas so it can exercise its oversight duties. And as I shared last week when we met on the topic, I'm getting questions from people at town halls in my district wanting to know how come we can't do that more quickly so we can do our jobs better. So with that, I'd yield back.
The lady yields back. The gentleman from Texas, Mr. Burgess, is recognized for his comments and questions.
Thank you, Mr. Chairman. And Ranking Member Jordan, I was intrigued by your statements on the, we all suffered through the Mueller probe, the Russia hoax in 2017 and 2018. These allegations were brought with no basis in fact, and there was no accountability for having put the country, put the Congress through what we went through during those 2 years. I just find it striking that now we have the same individuals proposing this legislation, but seems to lack the self-awareness of the problems that he himself caused the country by this reckless and partisan witch hunt that he went on.
Yeah, I mean, he said more than circumstantial evidence, more proof that there was collusion between President Trump and Russia, and it was just all false. And frankly, now we know it was. Now that we've seen information, now that the Durham report has indicted Mr. Zussman and Mr. Danchenko, and even the Washington Post has had to apologize and retract some of the things they wrote back then based on things Mr. Schiff was saying. And I think this is important for members of Congress to understand. This wasn't just any member of Congress making that statement. This wasn't just any chairman making that statement. This was the chairman of the Intel Committee, the committee that gets additional information than the rest of us get, going on television and saying something that was not true. That's the concern. And that is why so many Americans are upset with what took place for 3 years, all based on baloney. So much baloney that the Washington Post had to walk it back. So this is what's critical. And, look, but to Mr. Cole's point, we're happy to work with the inspector. We like the inspector generals. Inspector General Horowitz, his reports on what the FISA court's been doing, those have been tremendous. So we want to work with them. We want to get information. But it would have been nice if they would have worked with us and we could have put something together. But no, couldn't do it that way. We're going to just pile it in one bill. We're going to bring it in front of the Rules Committee, take it to the floor, and pass it.
Yeah, and I think that's unfortunate as well. And it certainly negates any expertise that the representatives of one half of the country literally have sent to Washington to represent them. And that unfortunately is that we see that scenario played out over and over again. We're going to see it several times today in all of the appropriations work that remains to be done, the debt limit. Why you think it's necessary to cut out one half of the representatives of the people of this country? It doesn't seem like any way to run a railroad. I do have I have a lot more I could say about this, but in the interest of time, I do have 3 amendments that I want to just briefly mention because I will be asking for them to be included in the legislation that the Rules Committee puts out later today. The First Amendment, Amendment number 6, which strikes Title II, which extends the statute of limitations for federal offenses committed by a sitting president or vice president. As written, this bill provides 9 specific reasons that a president must choose to justify the removal of an inspector general. The president is the head of the executive branch and has the power to appoint certain inspectors general for executive branch agencies and departments. This amendment would remove these 9 reasons and instead require a written communication from the president or from the head of the federal agency that is removing an inspector general to the committees of jurisdiction in both the House and the Senate, explaining the substantive rationale, including a detailed and case-specific reason for the removal or suspension of an inspector general no later than 15 days before the change in status. Now, in June of 2020, the Supreme Court ruled in Celia Law versus Consumer Financial Protection Bureau that the restrictions on the removal of the CFPB director were unconstitutional, specifically violating the Constitution's separation of powers. So this amendment would remove this unconstitutional provision while still requiring transparency and accountability in the offices of the Inspector General. And this provision was included in H.R. 2662 that the House passed in June. And at that time, myself and Ranking Member Comer offered this same amendment, but it was not made in order. Perhaps this time it could receive consideration by the full House, And Ranking Member Comer, I assume that you still feel that this would be an important improvement to this process. The next amendment would strike Title II of the legislation. Title II of H.R. 5314 extends the statute of limitations for offenses allegedly committed by a sitting president or vice president for the duration of their tenure and any period of time preceding their tenure in office. While we can all agree with the title of this section, no president is above the law, this section sets elected officials apart. Under current law, elected officials may be investigated for alleged commission of crimes, and any information that can be brought before the Congress Congress can then choose to remove the official from the office via impeachment. If impeached and removed, that individual would then be open to full prosecution, the full extent of the law, well within the statute of limitations, just like every other American. Title II is unconstitutional as the Sixth Amendment Speedy Trial Clause protects the accused against unreasonable delays between an indictment and a trial. Extending the statute of limitations in Title II of this bill would only further politicize the presidency and vice presidency and make holders of those offices targets of politically motivated investigations after their terms end. And I would urge the committee to include this and allow the amendment to be debated on the floor and allow members of the House to vote their will on that. And finally, Amendment number 11 to 5314. This amendment would require any congressional subpoena to be approved by both the chair and the ranking member or a two-thirds majority of the committee or subcommittee issuing the subpoena. Congressional subpoenas are powerful fact-finding tools. They're used to compel either testimony or the production of certain documents. However, subpoenas have recently become politicized weapons, with the majority party currently seeking contempt of Congress from anyone who doesn't immediately comply with a subpoena. And as I referenced last week, this invokes some of the worst excesses of the McCarthy era back in the 1950s, the House Un-American Activities Committee that created a blacklist of 10 individuals because they failed to comply with a subpoena. These measures are purely punitive and would not produce the information sought by the subpoena. This politicization reduces the effectiveness of subpoenas, creates mistrust when subpoenas are issued in a blatantly partisan manner, and currently, most committees simply require consultation with the ranking member of a committee and/or a vote by the majority of the committee, with at least a third of the members being present. By requiring with this amendment approval of both the chair and the ranking member, or at least two-thirds of the majority of the committee, subpoenas would be less likely to be used as a partisan attack, and this would improve the public's trust in Congress and our constitutionally and correctly placed oversight. So I urge that this amendment be made in order as well. And Mr. Chairman, I appreciate the indulgence, and I will yield back.
Thank you, Mr. Morelli.
Thank you very much, Mr. Chairman. And I'd like to begin by thanking two great New Yorkers, my dear friends, Chairwoman Maloney and Chairman Nadler, for their work, and I thank them for being here along with the ranking members of the two committees before us. So we have today what I consider essential legislation to reestablish the Article I prerogative established for Congress in its role as a co-equal branch of government. And I think the Protecting Our Democracy Act is a package of significant reforms that will restore the system of checks and balances, enhance transparency in the executive branch, hold government officials to high ethical standards, and protect our elections from foreign interference, which we saw happen in 2016. And it's been well documented not only by this House, by the Mueller report, but also by the Senate Intelligence Committee when the Senate majority was held by Republicans. And it was clear, and from what we hear from intelligence agencies, was attempted again in 2020, gratefully far less effort or far less ability to execute that. But I am reminded, and I don't know, and I appreciate the comments about whether this is directed at President Trump. I don't know that, and I appreciate Chairwoman Maloney's point that the president now is President Biden, so that's only who it could affect. But, I'm reminded Churchill said those who fail to learn from history are condemned to repeat it. So, I do think we have an obligation here, and under the previous administration, we witnessed that many of the safeguards protecting our democracy, which were simply norms throughout history, norms that were followed by virtually every president, every administration, are unable to be enforced. Norms are unable to be enforced against a president who is intent on undermining the rule of law, abusing presidential power, and escaping transparency necessary for proper congressional oversight. Another important part of Article 1, our ability to have oversight over the administration. After Watergate and the Nixon administration, Congress responded by passing a series of reforms aimed at better regulating campaign finance system, ensuring accountability in the executive branch. And I think this is yet again a time when Congress needs to look at what we need to do to protect our democracy, ensure that abuses that have happened in the past don't happen again. And this legislation, in my view, does exactly that. Ensures no president or vice president is above the law, prevents improper political interference in both civil and criminal enforcement matters at the Department of Justice, one of the most fundamental parts of our justice system, strengthened the Constitution's foreign and domestic emoluments clause, ensuring that federal officials, including the president, cannot use their position as a public servant to unjustly enrich themselves, enhances Congress's oversight in the powers that come with presidential emergency declarations, and reasserts Congress's constitutional power of the purse, guarding against abuses in federal spending. So I could go on listing the number of important things. Many of my colleagues have mentioned them. But there is one more thing that I do think that we here at the Rules Committee rightly would be concerned about, and that's we've recently seen the difficulties associated with enforcing a congressional subpoena against those who, in my view, assert frivolous legal arguments to avoid testimony or the production of documents. We've had to deal with this now in two different cases. It relates to contempt of Congress. So the legal strategy in these cases, I think it's been demonstrated, is often to merely delay the proceedings, and in the past, the strategy has paid off. So this proposal strengthens the enforcement mechanism Congress needs to properly enforce the subpoena, which is how we get information, which is how we get to the truth, how we are doing right now. And the committee chair and vice chair of the January 6th committee have worked tirelessly, along with the other members, to get information. But by expediting the judicial process to allow Congress to properly exercise its legislative and oversight powers while allowing judicial oversight and review of the subpoenas, I think is critically important. And I just want to conclude by saying I think the reform should have widespread support from both sides of the aisle, in that they will apply to this administration and all future administrations, both Democratic and Republican. And the question of the importance of Article 1 and legislative powers reserved to the people through the Congress, I think, is under attack. I think it's been, and it's not just, in recent times, throughout history, executives have always tried, it seems to me, to limit the reach and the influence of Congress as a co-equal branch. So I think it's critical for the future of our democracy. I believe standing idly by after witnessing some of the things that we've witnessed in the past few years would be an abdication of our duty and our obligation and responsibility, not only to the Constitution, but the people we represent. So with that, Mr. Chairman, I'll yield back.
Thank you, Mr. Rushenthaler.
Thank you, Mr. Chairman. I appreciate it. I think that we've pretty thoroughly covered the topic, so I'm just going to thank the witnesses for coming in today and yield back.
He's great. Mr. Desagne. Ms. Ross.
Well, I'm not going to be as great as Mr. Rushenthaler because I got a couple of amendments added on, so I just want to be thankful to the committee for that. I also want to thank both the chair of Oversight and the chair of Judiciary for their hard work on this bill. It's so important. And we know that our founders provided us with a government whose power is vested in 3 separate but equal branches. Each acts as a check to the others to ensure our rights guaranteed under the Constitution. and the system of checks and balances is at the very foundation of our democracy. James Madison wrote, quote, "Such devices should be necessary to control the abuse of government," end quote. Unfortunately, the prior administration eroded this country's well-established constitutional order when it shattered democratic norms, abused executive powers, and disregarded Congress's critical oversight role. As members of Congress, it's our duty to check executive branch overreach by holding presidents and their administrations accountable. That's why I'm a proud co-sponsor of the Protect Our Democracy Act. This bill will help ensure that our government remains of, by, and for the people. The American people want these critical guardrails to prevent any president, regardless of party, from abusing the public's trust. The two amendments I put forward today will further this mission to protect our democracy from subversion. My First Amendment protects poll workers and election officials who work tirelessly to ensure the free and fair administration of elections. In the wake of the 2020 elections, poll workers and their families have been subjected to unprecedented levels of harassment, violent threats, and intimidation, all spurred by the baseless conspiracies of Stop the Steal. As a result, in my home state, in North Carolina, and countless others, people have suffered critical shortages of poll workers. Ahead of the 2020 election, over 1/4 of counties in North Carolina had understaffed polling sites. This is unacceptable. The lack of poll workers threatens the right at the very core of our democracy, the right to vote. It creates a litany of barriers to the ballot box, from longer lines to fewer polling sites, and disproportionately costs vulnerable North Carolinians and people of color, cuts them out of our political process. My amendment would establish a task force within the Department of Justice to investigate and prosecute threats to election officials in collaboration with state and local governments. Threats to local election officials are threats to our democracy and must be stopped. The Second Amendment ensures transparency by prohibiting overreaching non-disclosure agreements that have no legitimate purpose and obstruct the public's interest in executive branch operations. In the previous White House, staffers were required to sign NDAs that far exceeded the bounds of lawful public employee speech restrictions. These NDAs infringed on the First Amendment rights of both government employees and the press that reports on matters of public interest. My amendment preserves the executive branch's ability to enforce secrecy requirements when needed to protect national security interests, and will not change current policies governing classified or controlled information. For the Americans to have faith in the White House and that it is working in the public interest, not just the president's interest, executive office staff cannot be routinely silenced by overreaching NDAs. I urge my colleague to support our founders' vision, our constitutional rights, and our democracy by advancing this bill and my amendments. Thank you, and I yield back.
Thank you very much. Ms. Fischbach.
Thank you, Mr. Chair. And I just have a couple of, this bill is just, there's so much garbage in it that I just don't even know where to start. It is, and I think that both Mr. Jordan and Mr. Comer pointed out that there are so many issues that are facing the country that we should be dealing with, and I just have to ask, what did we do today to help the American people? And this doesn't do it. This is, and I think it was Mr. Comer who said this is just an attack on the previous administration, on an individual that people don't like, or some people don't like. But I just wanted to, and like I said, there's just so much that you could go on and about, and constitutional issues, and just really, just stuff that isn't, it doesn't make sense to do. But I will just say, if Mr. Jordan or Mr. Comer have anything that they'd like to add to sum up or summarize or in closing, just give you the opportunity if there's anything. All right. Well, I appreciate the fact that all of the witnesses were here, and I will yield back, Mr. Chair.
Thank you. Anybody else wish to be recognized? Mr. Raskin.
Mr. Chairman.
Mr. Raskin.
Thank you very much, Mr. Chairman. And I want to thank the witnesses for their testimony on this excellent and urgently needed legislation. I want to start by just underscoring the central importance of Article 1 in the Constitution. You know, sometimes our colleagues will get up on both sides of the aisle and they will refer to Congress as a co-equal branch of government. And I want to get up and start screaming because that was certainly not the framers' vision of it. Article 1 creates Congress as the primary and leading branch of government. You know, the Articles of Confederation, the Articles of Association didn't even have a president in it. So the president was added solely to faithfully execute the laws adopted by the Congress. That's the role of the president. And if you look at the way Article 1 is structured, you've got dozens of provisions giving us all of our powers to regulate commerce, to regulate national commerce, reward, to encourage the government, not even in Article 1, Section 8, Clause 18, and all other powers necessary and proper in the foregoing powers. Then you get to Article 2, and there are four provisions relating to the president.
All right. Can you suspend? We're having some trouble with your link. You're going in and out a little bit.
Oh, I'm sorry. Okay. Well, let me try again. And I'll shorten my remarks. Is that better?
Yes.
Okay. I was just making the point that, you know, the president's core job is to take care to faithfully execute the laws that we, the representatives of the people, pass. That's the job of the president. There are only 4 sections that describe the president's power. One of them is all about impeachment, how you impeach a president who commits bribery, treason, or other high crimes and misdemeanors against the people. So I think the framers' vision of the Constitution was clear. We are a people that were created in revolutionary insurgency against kings. And we had a great fear of the idea of one person trying to run off with all of the power in an arrogant and imperious way. Now, that's something that the Congress historically has been. The framers really thought that members of Congress would come to identify with our own branch of government rather than with our political party. Unfortunately, there are those who think in purely partisan terms, and even worse than just identifying with a party, they identify with one person, one demagogue over the institutional interests of the Congress that represents all of the American people. That's an historic betrayal of the role of members of Congress who are supposed to be standing up for the institution against an executive branch. I don't understand what difference it makes whose crimes or transgression are necessary, whether it was the Trump administration or the Clinton administration or the Nixon administration. Who cares? I don't understand why people are bringing Donald Trump into it. That really is Trump obsession. You're so obsessed with hurting one guy's feelings that you don't want to make necessary structural reforms because you think somehow it's going to lower him in the esteem of his followers within the Republican Party. I mean, give me a break. So we've got to do what's right for the American people. We got to do what's right for our government. I'll just say a word on behalf of the emoluments provisions in this legislation, which I've had something to do with. We did see during the Trump administration an historic trampling of both the domestic and the foreign emoluments clauses. Millions of dollars coming in from Saudi Arabia, United Arab Emirates, lots of governments at the Trump hotels, at the golf courses, at the various businesses, the Chinese government with different licenses and different different privileges afforded to members of the Trump family, on and on and on. And, you know, we've never had to deal with this really in American history before. I mean, look at the elephant right over these, and no, you cannot. That completely abused it, and we do not have the mechanisms in place to deal with the president who decides to convert the presidency into an instrument of private self-enrichment, into a money-making operation. That is the ultimate betrayal of the view of the founders, who thought that government must be an instrument of the common good and not an instrument of money-making for the president and his friends and his corporate buddies and his family and the coterie of people who come around him. So we absolutely need to add muscle to the Emoluments Clause provisions so that we don't move into the rest of the 21st century with people thinking that they can exploit the office of the presidency for purposes of making money for themselves and their businesses and their families. Donald Trump was a president who continued to keep businesses going, dozens and dozens of businesses. He didn't even put them in blind trust. He just said he was going to turn over day-to-day management to his kids. And yet these businesses were continued to engage in all kinds of contracts with the government. There were U.S. government agencies that would go and stay at their hotels. There were foreign governments that were spending money there. And so all of that is an outrageous betrayal of the constitutional design. And we've got to deal with that along with all of the other provisions relating to inspectors general and so on. So I just want to say I'm in very strong support of this legislation, and I'll yield back to you, Mr. Chairman.
Thank you very much. Has everybody asked their questions? I think I don't hear anybody else. So with that, I want to thank the panelists for being here. We appreciate it, and you are free to go. Are there any other witnesses for H.R. 5314? If there are, we will hear from them at the end of today's meeting. I'd now like to call up S1605, the NDAA. I'd like to welcome our witnesses to provide testimony on S1605, the National Defense Authorization Act for fiscal year 2022. Chairman Smith and Ranking Member Rogers, we are delighted that you are here. Thank you. And thank you. I don't know where Adam is. I know you're here. Yeah. Well, did you didn't see Adam out in the hallway, did you? All right, we'll give him a minute, and if not, we'll just begin with you.
Get Mr. Smith.
There we go. Yeah, he was, yeah, I should have checked, yeah. All right, welcome, Chairman Smith and Ranking Member Rogers. Chairman Smith, we will yield the floor to you.
Thank you very much. I appreciate the opportunity to be here as always, and I appreciate the Rules Committee work, certainly in this bill throughout the process, as we've said many times. And this bill, as I suppose with many, every member has an interest to one degree or another, and we've fielded a lot of proposals throughout the process, and I know you have as well. Your staff has done a great job of working with our staff. I just really want to emphasize how important it is that we pass this bill. When we get down to the end here, we tend to talk about all the things that we disagree about, and we forget about all the provisions that we have agreed about that are in the bill that are also important, I believe, to us doing our job on the Armed Services Committee, which is very simple and straightforward. exercise oversight in the Pentagon and do our level best to give the men and women who serve the tools they need to carry out the missions that we as a country are asking them to do. And the work we do on that is very important. I mean, just to give you a couple of quick examples of what we work on, technology and innovation is crucial right now. When you look at our competition with China specifically, but also with our other adversaries like Russia and Iran and North Korea, national terrorist groups, and others, we've got a lot of work to do to catch up in a rapidly changing world. And one of the things we agree on is that the Pentagon has been a little slow in terms of software acquisition, innovation, because of the nature of it. Well, we had a huge task force that was set up, led by Eric Schmidt and Bob Work, to take a look at that. It was focused primarily on AI, but the broader idea of technology was certainly part of it, and they came up with a whole series of proposals. Thanks to the leadership of Jim Langevin and his subcommittee, those proposals are in this bill, okay? And they're crucial to helping the Pentagon get to where they need to be. We have an issue on computer chips and the fact that we're too dependent on China. We have a provision in this bill to help deal with that. Hundreds of provisions like that are contained in this bill, and they're not the things that most people focus on, certainly not the things that I've been fighting over in the last week or so as we deal with what Republicans want and what Democrats want, what the Senate wants and what the House wants, and what some outside committees want. But I want everyone to remember as we're working on this, that is the core of what Mr. Rogers and our committee and our staffs do, and that really matters. Now, as it happens, the defense bill is one of the few bills that works its way through the process, is bipartisan and bicameral and gets passed, so we try to carry other items on it. We have the Foreign Affairs Authorization Bill is on it this time, and that was a fight right down to the wire. We tried to carry the Intel bill on it as well. That was a fight right down to the wire that we were not successful on. But as we talk about the things that we didn't get in this bill, I just hope that we don't forget about the things that we did and that are so important to the basic job that we have to exercise oversight over the Department of Defense. And it's both a matter of, in many cases, giving the Department of Defense the tools that they need to meet those challenges that I just outlined, and in some cases, nudging them towards doing what they ought to do to better meet those challenges. For instance, we have provisions in this bill to help deal with creating more competition on programs like the F-35 that we don't get trapped, so we don't get trapped in the vendor lock situation that we got trapped in. We're trying to revise the idea of having a competitive engine as a possibility to do that. We're trying to hold the contractors accountable for the sustainment costs and how high they are. All of that really matters, and I hope we recognize that. It is a delicate balance when it has to be bipartisan and it has to be bicameral. And let me say on Mr. Rogers' behalf, I think the bicameral thing is turning out to be a much bigger challenge than the bipartisan as I've heard. In fact, we were going to jokingly propose at the end that why don't we just create a unicameral legislature? Can we slide that into the bill at the end? That solves all of our problems. But jokes aside, the point is that's what we got to pull together in order to move forward. And Mike and I and our staffs and Senator Inhofe and Senator Reid, who are great partners on this, and their staffs, we navigate through all of that and create the best product we can. And the last thing that I will say for all members on this is the sexual assault reform provisions that we have in this bill are the most transformational thing that has been done in this committee in my 25 years of serving on it. As we all know, for years we have dealt with the reality that sexual assault is not being adequately dealt with in the military. There's 1,000 other things that can be said about it, but that sentence I don't think anybody would disagree with. And in this bill, in a bipartisan, bicameral way, with a lot of disagreement about exactly how to handle it, and thanks in large part to the leadership of Jackie Spear on our committee, we take sexual assault and all sex crimes away from the commander and create a special victims prosecutor's office to give these crimes the attention they deserve. And not just all sex crimes, but any crime that could be related to a sex crime is given to that special victims prosecutor. And we create the crime of sexual harassment in a special investigatory unit separate from the chain of command to investigate that. This is a huge change that a whole lot of people didn't really agree with, but ultimately went along with to get into this bill. I To miss that opportunity, I think, would be, frankly, a betrayal of our responsibility to the men and women who serve in the military. It's a good bill. It's not perfect. Every single person has something in it they don't like and something that didn't get in it that they wished had. Every single person involved in the process. It's not just you, everybody. And we managed to get a deal together that I think creates an outstanding piece of legislation that upholds our responsibility on the committee, and I might add our responsibility as a Congress. So I urge support for the bill, and I thank the Rules Committee for all their work that they've done to bring us to this point.
Thank you, Mr. Rogers.
Thank you, Mr. Chairman and Ranking Member. I appreciate y'all having us here today. And I really appreciate your staff. It's been very good to work with as we've tried to get to this point. I appreciate the work they've done. And I can't overstate what a great partner Adam Smith is and a real leader on our committee. He has been tireless trying to get us to a good point. And it's not, it seems like it's a never-ending set of challenges that keep popping up. But he's done a great job of navigating that. He described accurately how good this bill is. And he also is right. There's a lot of stuff in here that I'd rather not be in here, but that's just part of the process. There's a lot of stuff in here that I'm very proud of. But we've passed this authorization every year for 60 years, and there's a reason that it gets done when nothing else does. And this is overwhelmingly important for our country, that we keep our Defense Department authorized and we exercise our oversight in its direction. This is bipartisan, it is bicameral, and the bicameral part is the hardest part this year, unfortunately. But I hope that y'all will not allow any amendments to be attached to this, because we have really worked hard to fight off problems to make sure that when this gets to the floor, it gets overwhelming support. And I think any amendments that might be attached could be problematic in that endeavor. But with that, I'll shut up and let you know I appreciate y'all and look forward to any questions you may have.
Well, thank you both for being here, and thank you for your hard work. You know, I think there are a lot of good things in this bill, and there are, and I, as you know, and I'm somebody who usually votes against the NDAA because I think the amount is too high. It's my own personal philosophical view, but that doesn't prevent me from thanking both of you and your staff. Thank you for your compliments to our staff here, both Democrats and Republicans on the Rules Committee, but your teams have always been responsive, and you have a tough job trying to, in very diverse caucuses and conferences, trying to find a middle ground where you got enough people that will vote for it. Mr. Smith mentioned some of the bicameral problems. My colleague, Mr. Perlmutter, as you know, you've heard from, has been pushing this safe banking bill for quite some time. And we voted on it last on 4/19/21. 321 people voted for it, and 101 people voted no. It was 215 Democrats and 106 Republicans. That's a pretty strong bipartisan vote. And yet every time it gets sent over to the Senate, I think it's the Senate Majority Leader. I don't really quite know what the hell his problem is, but what he is doing is he's making it very difficult for a lot of small businesses and minority-owned businesses too, dealing with the issue of cannabis, to be able to move forward and to expand and to hire more people. And so I know he's not here right now, but you've heard, I'm deaf in my left ear hearing him telling me how frustrated he is over this. And I share that frustration because, you know, I mean, you know, at some point when we talk about getting to deals, you know, it just can't be one person, no matter who he or she may be, that just says no. So anyway, just for the record, I think I speak for at least the Democrats on this committee when I say that there is a great deal of frustration over the way the Senate has treated him and this issue, that every one of us have constituents who care about this issue. So,
If I
yeah,
could
go ahead.
just, because I think it's a really important issue, and I've worked very closely with Congressman Perlmutter on this, and I think he's right. And the impact of this as a practical matter to not have the Safe Banking Act is incredibly dangerous for small businesses that, basically they have to run a cash business. They can't do the normal banking that is available to them in the states where marijuana distribution is legal. And, we've worked this issue, as you said, worked in a bipartisan way. And, I pushed this so hard. I mean, I even seriously considered saying, we're just going to put it in and the Senate can deal with it. But the bottom line is, if the majority leader in the Senate has this opinion, at the moment, it's worth noting that the minority leader has a similar position in the Senate, that they don't want this included. That's not the way the process works, because I'm sure they'd come back and say, well, here's 5 things that we wanted that you didn't do. In this case, I think this is a special case, because not only are they not moving this forward, they're not having a hearing.
Right.
Okay, you
Yeah,
say you don't want
right.
it this way. Well, okay.
Right.
This is a huge thing that is very, very strongly supported. You got something different, give it a shot, and they're not doing it. So, I pushed this as hard as I've ever pushed anything, but at the end of the day, I agree with Mr. Rogers. We can't have amendments to this. It's a house of cards. You pull one, and then you got 25 other people say, well, what about my thing? And then that leads to another 25 people say, what about my thing? So we got the best deal we could get, and we hope that it is not amended so that we can get it to the Senate through the process.
Well, at this moment, for those who complain about the fact that we haven't addressed the issue of safe banking, and by the way, criminal justice issues with regard to cannabis, the blame is over in the Senate, period. And so, and again, I know we can always point out what we don't like or was missing in the bill. I'll point out one other thing, and then I'll move on. I'm the author of the Magnitsky bill. It's a human rights bill that allows our government to sanction corrupt individuals, human rights violators all around the world. And the authorization for that was originally in the bill to be extended, and the criteria as to the tools the administration could have to go after the bad guys was expanded. And my understanding is that Republicans, I think on the Foreign Affairs Committee, weighed in against that. I just want the record to reflect, it is outrageous. If this country stands for anything, we got to stand out loud and foursquare for human rights. That bill went through the Foreign Affairs Committee as part of the China bill. To the best of my knowledge, nobody said a word when it was being marked up, and all of a sudden they have a problem with it. It is outrageous. It really is. It's sad. I'm not blaming you. I know everybody has to agree on everything here, but I just want the record to reflect that. And the final thing I'm going to say, and it's on a more positive note, that again, it is tough to get legislation through the House and the Senate, and you both have conducted yourselves, I think, the way we expect chairs of all committees to conduct themselves, and you have been receptive to all of us, Democrats and Republicans. And again, I have some philosophical issues with the bill, but I don't want, that doesn't detract from the respect that I have for both of you and your teams for the work that you have done. And I thank you for being here, and I turn this over to Mr. Cole.
Thank you very much, Mr. Chairman. I think this will probably be the most bipartisan part of our hearing, maybe of our term. I said so many nice things about both of you behind your backs. I feel compelled to say a couple of them while you're here. I want to join the chairman in really congratulating both of you. I think this has been an extraordinarily bipartisan and open process. I know that if either of you got to write the bill by yourself, it would look a little bit different than what we see. But the point is, nobody gets to do anything by themselves. And the reality is, you work together very well in good faith, and I think have assembled a really good product. Disagree with my friend a little bit, the chairman. I would put more money in here, not less. I think with the Chinese saber rattling in the Taiwan Straits, and with the Russians seriously contemplating an invasion of Ukraine, we need to send them an unmistakable message about American resolve. I think it's actually very important for the president, who is on a mission that we all hope on both sides of the aisle succeeded today in letting the Russians know that there would be consequences to actions in Ukraine, that we see tangible proof that America can act together in situations like this. And I think this is part of the tangible proof. I think you send a direct message. I know this bill wasn't written with that only in mind or for this particular moment, but I think it's a timely moment, and it's very important that the Congress not be divided on this. Strangely enough, as this comes to the floor, I know there'll be bipartisan opposition and bipartisan support, and I commend you both for that. I recognize that my view isn't the only view around here, but I'm very pleased that in this case, at least, there's bipartisanship on both sides, so that it does not come down to a partisan thing at all, and that America can move quickly. So this is just a model of how legislation should work. Your committee worked together. You reported your initial bill out 57-2, as I recall. I know there's been changes and adjustments along the way, and people fall on and off the wagon, but the point is you've kept the great majority of members on both sides of the aisle in this. To Mr. Perlmutter's problems, I feel his pain. I voted with him on that legislation. I think he's right about that. I would be happy to give him a lesson in patience. I first passed the carcieri reform bill attached, working with my friends in the Democratic Congress in 2010, and it got scuttled by a Democratic president. I got it through again, Democratic Senate. I got it through again because the President of the United States, Mr. Obama, President Obama at the time, would have signed it. I got it through again, and the Republican Senate didn't choose to take it up. My good friend, Miss McCollum, just got it through, working with her last week, and I suspect it has a very uncertain fate in the United States Senate again. And that's just, in these cases, the objections have been institutional, not partisan. I think we've been on the right side of this every single time, as my friend Mr. Perlmutter felt. So he's only waited 3 years. I've waited over a decade. But you just got to keep at it. And as important as I think those things are, they're very subordinate to what the two of you are doing. You're talking about the defense of the republic, and if we had to vote some of these things off, even that I support, so that the larger bill got through, I would certainly be supportive of that effort, and will be working with you on this. I'd be remiss not to compliment your counterparts in the United States Senate as well. I appreciate you both mentioning Chairman Reed and Senator Inhofe. I think they are very serious legislators and serious negotiating partners with you, and I appreciate the professionalism of the relationship and that you both have maintained with your colleagues on the other side of the chamber, because we all know, I think we're going to send some things over here, we may agree or disagree, that aren't going anywhere in the United States Senate. This will, because you guys have done it, and it'll do it in short order, and it'll do it at an important time for the country. Last point I wish to make, Mr. Chairman, as important as this legislation is, and as good an example as our chairman and our ranking member and their colleagues have set, it's not going to mean much if the money doesn't come after it. And I say that as an appropriator and one very interested at arriving at a deal that reflects the numbers that you have in your authorization bill. It would be a shame if we just got this done and felt like we'd done our job. If the money's not there to carry through the excellent work that your committee has done once again for the United States Congress, and more importantly for the country, then it won't matter very much. Well, I wouldn't. It always matters, but it has to have the wherewithal behind it. We've sort of put off, I think, dealing with some of the serious questions and appropriations while we focused on other legislation. We can debate the merits of that, but it needs to get done. We've now got till February the 18th to get an appropriations deal, and I hope we do. And otherwise, we'll end up in the CR and kick the can down the road. And the money that it takes to implement the excellent work that you and your committee have done just simply won't be there. And that's a bad message. This is the important first message to both the American people, that on their behalf, when it's really important, we can work together. And it's an important message to our friends who sometimes doubt our ability to do that. It's an exceptionally important message to our adversaries that this country, when it comes to defense and when it comes to speaking with one voice, can do it. And so you've done your part. You've passed the baton off. Once we get this across the House floor, which I'm confident we will, and once it gets through the Senate, and I'm confident that will happen, the President will sign it. My colleagues and I on the Appropriations Committee have to follow up with that. And, and leadership is involved in that, too. We're going to need really good cooperation from the leadership of both the Senate and the House on both sides of the aisle to get to where we need to go to provide the resources that I think you two have very wisely, in concert with your committee, directed in the right places. And like I said, if that number got higher, it wouldn't bother me a bit. Because I think with inflation and given the seriousness of the challenges, and I think they've gotten much more serious since you began your work. I'm not going to debate Afghanistan endlessly, but I do think some of our enemies draw conclusions from that. We need to correct those conclusions and let them know that when it comes to dealing with near-peer rivals, we see how serious this is, and we intend to send them a direct message, and we intend to stand with our friends. And we're not looking for conflict, but we are more than prepared to deal with it should it happen. I know the President certainly doesn't want no President would want to deal with a conflict that we could potentially have with countries as significant as China or Russia. But again, I think sending them this message by passing your bill and then making sure it's appropriately funded is the best thing that the Congress could do to help the President of the United States achieve his objective of making sure that somebody doesn't make a bad miscalculation overseas and test the resolve and the ability of this country. So again, with that, thank you sincerely for really excellent work. Thank you for setting the gold standard of how we deal with difficult issues and resolve them. I hope your example is more widely emulated in the Congress, but you do your work where you can, and you hope it has an impact elsewhere. And I think you both can be really proud of what you've done and what the membership of your committees have done. And I'm very proud to be represented by both of you as an institution as you negotiated with our friends in the Senate and worked through and brought us a product. And I, too, agree with both of you. Even though there's some things I would have liked a little different, even though there's some amendments I could easily support, I would certainly respect your wishes and would not support any amendments to the work that you've done. I want to maximize your chances of getting this across the line, and so I'll work with my good friends on the Rules Committee and certainly with my friend, the chairman, to try and do that. So again, just from a very grateful member, thank you for what you're doing. I look forward to supporting it on the floor this week, and I look forward to seeing it signed into law. With that, I yield back, Mr. Chairman.
Thank you, Mr. Raskin. Ms. Scanlon.
Wanted to, again, echo my colleagues in thanking the committee for its work. I know that it's a massive undertaking every year, but so necessary to, continue vital modernization programs and just secure our national security. The NDAA obviously has some very important policies for my district, including funding for the Block 2 Chinook helicopters and the V-22 Ospreys, which are all manufactured in Ridley Park, Pennsylvania. 4,500 men and women who build these incredible machines are so proud of the work. They are very much like those machines in that they are hardworking and they just get the job done every time. So we're very proud of them as well. The NDAA also includes funding for the 5th of 5 national security multi-mission vessels, which are being built in the Philadelphia shipyard, which of course is the home of the Philadelphia, birthplace of the Philadelphia Navy, and is so important to our national security, to our national economic security, as well as our regional economy. So we're really interested in seeing these vessels getting produced. In fact, I think this Friday there's a keel laying for one of the multi-mission vessels at the Navy Yard. So we're looking forward to seeing that happen. Particularly appreciative as the sister of a woman who served in armed forces of the important reforms being made to the way the military handles cases of sexual assault. This has been a long-standing goal to move this process forward, and it seems as though we're finally making some really important progress there. So that's appreciated. And I just have to echo the chairman's remarks. Pennsylvania, as Mr. Reschenthaler and I know, we have the state has legalized medical marijuana, so we have quite a few businesses that are impacted by the inability to use the federal banking system, and for that reason supported Mr. Perlmutter's act and look forward to continuing to doing so if we can figure out, once again, how to get the Senate to do its job. So thank you. I yield back.
Dr. Burgess.
Thank you, and thanks to our two witnesses for working so hard on this. Ranking Member Rogers, if I could just ask you a question. You mentioned you didn't want to see this come forward with any amendments that might be deleterious, but conference report coming to the floor is generally not amendable. Is that correct? Is this different?
Yes, we would have loved to have had a conference and be bringing a conference report to the floor, but unfortunately, our counterparts on the other side of the Capitol could not get their bill to the floor for votes. They would like to have had amendment debate and so forth. So time just ran out. So this is something that the chairman and I started negotiating with our Senate counterparts after their Senate bill came out of committee. So we have been basically conferencing this ourselves for the last 3 months, two to 3 months. And once it became obvious that we didn't have enough time in the calendar left with parliamentarian to have a conference report, we just went ahead and ironed out the last details. So basically, we're taking what would be a conference report and putting it in a Senate bill over here. So when it goes to the Senate, it will get privileged and be taken up right away. So this, to answer your question, this is not our conference report. If you choose to make it amendable, it could be amendable.
We're asking you to choose not.
Well, but you've disclosed the power that we hold.
You do have.
And it is seductive.
You do.
But let me just, that as a practical matter, going back to the Senate, that it is a privileged and it is not amendable at
It
the
is
Senate.
privileged, it is amendable over there as well.
And
privilege was not that. That's right.
But again, as a practical matter, so if the problem was Senate amendments which delayed getting a conference, are those amendments likely to still be?
No, they can't get past cloture to get amendments.
If I could take a stab at this, I mean, the basic process now is, as Mr. Rogers said, we've got the agreement we've got, and you make any changes to it, it's, the odds of us being able to continue to go forward are remote, because everyone's going to want back in there. But because, as you pointed out, we weren't able to get into a formal conference committee, it is possible to do that. We were simply asking the various, people who are in a position to affect that to choose not to honor the agreement and honor the bipartisan, bicameral agreement, and move it forward. Because if we change it, we're right back into a negotiation that is unlikely to get us a positive result at this late date.
Let me just ask another question that comes up every time we do the NDAA, and the issue of the indefinite incarcerations, the habeas corpus issue, is that going to be an issue on the NDAA as drafted currently?
No.
Very well. Well, again, I commend you. I know it was a long process through your committee, Mark, and we all spent a lot of time up here on this earlier. Yeah. It's been interesting to watch the process unfold. I will resist the urge to vote in favor of Mr. Cole's motion for an open rule, and I get back.
Mr. Morelli.
Thank you, Mr. Chairman, and thank you to the chair of the committee and the ranking member. We had the good fortune of being added to the House Armed Services Committee in January, so although I've only been there a short time and feel like a probationary member still, and it'll take me a while to feel like a full member, I do want to say, first of all, I think this is a very good bill, made all the more impressive by the challenge of getting it actually passed, which I think, says a lot about it. But I just wanted to say, having now served through the last year, how much I appreciate the way the committee goes about its business. And I think that says volumes both about the chair and the ranking member. I think the attitudes of the member when they come in the room. I think the staff is extraordinary as well. And I had a number of things in my district which are included here, which I won't recount, but I don't think it's necessarily special to me, but I think it's representative of how the leadership of the committee takes very seriously the input of the members, how seriously the staff takes seriously the interest of the members. So I have to say it's been a real privilege to serve, and we have many challenges around the world, but I'm grateful to be a member and to participate and hopefully in some small way contribute to the great work and the bipartisanship. So I'm very grateful to both these gentlemen and my colleagues, and I also want to echo, although no one else stuck up for you, Ed, I want to just say.
He's back. We don't have to say any more nice things.
I want to say how there was unanimity about the issue that Mr. Perlmutter has been talking about, and I'm sorry for Mr. McGovern's left ear, which apparently won't ever be the same again. But this is important, and I obviously don't need to tell each of you how important it is, but I think there is a general agreement among the members here that the United States Senate needs to somehow respond in a more constructive and a more thoughtful way on a really important issue. And I represent a state which has recently gone from simply medicinal to recreational, and I know people have different views in different states, and that's fine, but we need to really make sure that there's safety. And I think it was Mr. Cole mentioned the importance, particularly for small businesses who are dealing in all cash businesses. Mr. McGovern said it well. I won't repeat all this, but this is an important issue, and I hope we get some resolution or at least get to move this forward. But again, my great thanks and gratitude to you for the extraordinary
Will the
work.
gentleman yield? Mr. Morelli, would you yield for 1 second?
I'd be delighted to yield to Mr. Askin.
Thank you, Mr. Morelli. In my haste to just move things along, I did not exercise my right to speak on this, but I did want to echo your statement about Mr. Perlmutter's work, which has been superb in terms of advancing the safe banking legislation, which has the overwhelming support of the House of Representatives. And, we have to do whatever we can to push it forward. And if the Senate can't see fit to agree to do it in this context, we've got to find another vehicle to make that real. So, I want to thank the chair and the ranking member for their work on this, but please understand that very strong sentiment on our committee that Mr. Perlmutter speaks for a lot of the House of Representatives in saying we want this to be an issue that's resolved. And I'll yield back to Mr. Morelli. Thank you much.
No, thank you, Mr. Askin, and I could not have said it better. I feel the same about the chairman's bill, and this is really important. That I think, particularly as we're trying to get this done under very difficult circumstances, I think the Senate needs to be more respectful of the wishes of the members who are in this chamber. And in any case, thank you both, and to the committees and the staff for the great work, and I'll yield back, Mr. Chairman.
Mr. Rushenthaler.
Thank you, Mr. Chairman. I appreciate it. And I want to thank the ranking member and chair for all the hard work you and your staff put in the bill, and just for making sure that our military has what it needs to get the job done. And I want to say I'm especially pleased with two provisions. Number one, is I'm very pleased this bill does not include any red flag provisions. To be clear, our armed forces, our members of our armed forces have no infringement of their Second Amendment rights. So I'm very pleased with that. And second, I'm very pleased, as my colleague from Pennsylvania had alluded to in her remarks, that there is a UCMJ reform that's included. And I think that the addition of special trial counsel. As a former JAG, you get caught up in the alphabet soup that's so common in the military. But the fact that we have special trial counsels that will make the decision to charge cases, I think it's a huge benefit to military criminal justice. I wish there were more covered cases, but this is a really good start. I think it's good because our COs will be able to focus on military readiness, war fighting, leading, rather than being put in the awkward position of trying to play DA without the appropriate training to do so. So that's a big win. So with that, I just want to thank you again, and I yield back. Thank you, Mr. Chairman.
Thank you very much. Mr. Desagne,
No, I don't have anything to add. I yield back.
don't you want to say anything nice about Mr. Perlmutter?
I'm not expecting
I think the last said about, Mr. Chairman, the less said about Mr. Perlmutter is in everybody's benefit.
Ms. Fishbach?
And just start out, Mr. Chair, I'm not going to say anything nice about Mr. Perlmutter either. Maybe some other time. But real quickly, I just wanted to ask one question just for confirmation. First, associate myself with the comments of the ranking member, because I'm very happy with the way this turned out. But a really big issue in my state is the National Guard, Minnesota National Guard C-130 fleet. And the delegation, the entire Minnesota delegation has been concerned about that funding and wanted to preserve it. And I just want to confirm that it is, that this, that the agreement does protect that fleet.
It does.
Thank you very much. And with that, I yield back, and maybe some other time we'll say something nice.
Thank you. Ms. Ross?
Thank you, Mr. Chairman, and thank you so much to the chairman and the ranking member for doing just unbelievable work. The first rule that I handled was for the NDAA on the floor, and it was an honor to do that. It was an honor to do that in particular because I represent North Carolina, a military state, and I was with the President and the First Lady and several of our colleagues serving the troops right before Thanksgiving at Fort Bragg, which was truly an honor and much more personally moving than I thought it was going to be able to do something for our troops. And so passing this bill will be doing even more for our troops. I also want to echo the appreciation for dealing with military sexual assault and for dealing with TRICARE in this bill. I think our female service members deserve our respect. They deserve what they need, both in terms of justice and in terms of their health care. And then I would be remiss if I didn't say something kind about Mr. Perlmutter. And I would just say, you know, a lot of people think that his bill is a banking bill. I consider it a public safety bill, which is why it was in the NDAA to begin with. And we just have to get it over the finish line. So any suggestions, you've been negotiating with the Senate, any suggestions you have for getting the Senate to take this seriously as a public safety issue would be greatly appreciated. And with that, I yield back.
If I may just comment quickly, and you know, as self-serving as this comment may be, even though we didn't get across the finish line, I think the process that we've gone through and the public attention that this has brought has moved the needle. The pressure has been turned up enormously on the Senate, because to this point, the Senate's general position was, I'm sorry, what do you want? Yeah, no. And that was the end of the conversation. Okay, we created a situation where that simple answer was no longer acceptable. And that's the approach we try and take on this. And I want everybody to understand this. I'm kind of relentless in the way I approach things, and you ask me for something, I'm going to find out why. Okay, you know, and a lot of times, Senate, you know, they don't want to just no and leave it at that. You got to push them. Well, why? Well, who objects to it? Okay, and if you can really sort of narrow it down, you can back people into a corner, and it's like, okay, if that's the only argument you've got, and then you succeed. You know, not always the first time, but eventually. So don't think that this process hasn't been helpful. And I had a conversation earlier today talking about, well, do we want to continue to accept or support, at any rate, outside committee issues going into the NDAA? And it's always this time of year when the first reflexive answer is sort of no. But that's not where I'm at. Even after all this, and no matter what anyone decides, I think it is incredibly important that we use this vehicle to push those broader issues, given how difficult it is to move issues through one committee. You know, I don't think a committee chair should just say, if I don't like it, it's not happening. I think as a committee chair, you have a responsibility to your members, not just your own personal opinion. But if you run into committee chairs who are doing that, then using the NDAA process to force that issue in a more democratic direction, I think is an incredibly important thing that we do. And whatever the pain is at the end of the process, I think we have made progress on this issue, and the Senate is under a lot more pressure to do something on what is, and you've all said it better than I can, it's incredibly important. So glad we pushed it, and you know, we'll keep pushing it. We just didn't quite get there this time.
Thank you. I think everybody's asked questions except Mr. Perlmutter.
And I just want to thank everybody for their kind comments, and thank you too, Mr. Rogers, Mr. Smith. The Safe Banking Act did not arise in your committee. It came out of financial services, some degree judiciary, obviously is a public safety. You know, we had the statistics, Mr. Cole, for armed robberies of dispensaries in Oklahoma that have occurred. California, within the month of November, just in the Bay Area, 25 armed robberies, 2 people shot, just because there's so much cash. Within the bill, and the reason it was germane to the NDAA was because of the components concerning cartels and foreign money laundering. So a national security nexus to the piece of legislation. And obviously, putting it in the NDAA was not my first choice. And the refusal by the Senate to, and Mr. Cole, you talk about regular order a lot, and I think one of the disappointing things, at least with this bill and a number of other things, we do go through regular order and then run into a vacuum, some kind of emptiness over on that side, and it is frustrating. And so then what you have to do is you have to take it up a notch, take it up 2 notches to get somebody's attention. Well, we took it up in several notches by putting it in the NDAA, and you too, and I appreciate the work, you know, you did in knocking on that door and continuing to knock on the door. Precisely why the majority leader, Mr. Schumer, is opposed to this is still pretty much a mystery to me. Makes no sense because of the public safety aspect, the minority business aspect. Without the ability to have banking, many small businesses, veteran-owned organizations, women-owned businesses don't have access to capital. So you've got a public safety thing, you've got access to capital, and we're at 47 states. Every territory and the District of Columbia allow for some kind of cannabis use, whether it's medical or fully legal or cannabis oil. So it's not, you're not putting the genie back in the bottle. You're just not. We got to deal with it, and they've been unwilling to deal with it. So I appreciate advancements that have been made by the negotiations you two have undertaken. Now, obviously, and Adam, Mr. Smith, you have heard my ire and my irritation and my anger because people are getting killed. They're getting robbed, and we're making no move. We now have made some advancements, but this thing's been sitting there for 3 years. 3 years. 2 years when Senator Crapo was the chairman of Senate Banking, and for them, at that point, it was too big and too broad. The bill was too big and too broad. Now Democrats are in charge, and it's too narrow and too limited. But people are still getting killed and robbed. And so this is, it makes no sense to me. And I think for me personally, you know, the question is, do I start really throwing procedural wrenches into everything? You know, my intention today, and I just had a long conversation with the Speaker, who too has been making real efforts to advance this piece of legislation and let it see the light of day and get a hearing on it and get a vote. That's all I want is a vote over there. And not just deep sixth forever. So my intention was to Mr. Cole, you'll be interested in hearing this, advancing an amendment to the rule to have the Safe Banking Act become part of the rule. I'm not going to do that. I know that it would potentially breach whatever kind of oral agreement you have reached in terms of your four corners. You know, there's not a conference report. There's not something where people signed on the dotted line, but you have an agreement, and I'll respect that. But I do, you know, I'm not raising the white flag on this thing. We're going to keep bringing this up, and, you know, whether it's on a CR or you know, some other kind of thing until we get this thing moved. I just want an up or down vote. And I think if, you know, there are 40 co-sponsors on that bill, 10 of whom are Republicans. So here you're doing it through regular order, with hearings, big bipartisan votes, with strong participation by the minority party. It's everything you want to do in this place, and you get, I don't want to say it in public, on record, but you don't get the attention because you need to be the squeaky wheel. So I thank the committee for kind words, for really supporting me in this effort. I'm going to work with the Speaker to work with Senate majority and minority leaders to get this thing heard in one fashion or another, or I really am going to start gumming up the works.
Would the gentleman yield?
Yeah, of course I would.
Just quickly, I wanted to invite the gentleman to come down to H-152, join me in a drink. You can mourn, you know, what happened here. I'll mourn Carcieri. We'll both swear at the Senate. It'll be a wonderful institutional bonding moment.
You know what? I'm coming right down there with you. So I appreciate the gentleman's willingness to work on this. Both of you at the outset said, look, we'll take this as far as we can. And you did. Thank you. The other thing I want to, just getting back to the real topic of the NDAA, is, you know, obviously Colorado has a strong aerospace industry. We've had the Space Command. We want to continue to have the Space Command in Colorado Springs. At the very end of the Trump administration, command was moved to Alabama, or proposed to go to Alabama, no offense. And clearly, that's something that we oppose and will continue to oppose. It's a major function in our state, and we think that there were some missteps, misstatements, misdoings, if you will, malfeasance in connection with that, and we want to get to the bottom of that. With that, I yield back.
Well, thank you very much. Let me just close by, again, thanking Mr. Perlmutter for his statement. I should say with the record that, and I think the chairman knows this, we came this close to saying the hell with it. We're going to attach this to the bill. We understand that that may have meant that it couldn't pass the House with Republican votes. We also understand that there were problems over in the Senate. But, you know, we can do things like that here. And so Mr. Perlmutter, I think, you know, out of respect for the work that you have done, did not want to see the defense bill derailed. But I think, as you can tell, I mean, his patience is, you know, is gone. I don't know if you ever had patience, but anyway. I say that for the record, and I hope our Senate colleagues are listening, because one of the responses that would have been nice is to say, okay, we'll work with you over the next 3 months to tell you what we need in the Senate, and you tell us what you need in the House, and let's get this done. And you know, we didn't get that yet. So I think this is not the last effort at all of this. And finally, I think we speak for everybody here. Your staffs have been incredible to work with, and Paul Congelli with the chairman, Chris Feason, with ranking member, there is incredible respect for them on both sides of the aisle, and they're always, responsive and returning calls and trying to work things out. And so we want you to know how much we appreciate them. We know you do as well. So there are no other questions here.
Chairman, I actually just one last observation for Ranking Member Rogers and for the chairman. We talked about the draft issue in the earlier hearing that we had here, and of course, a lot of controversy over the language in the bill, and my understanding is that's to be taken care of. But, Ms. Rogers, you noted earlier that it is time to move. We have an all-volunteer military. We have had for over 40 years. Our military is the envy of the world. It is time to remove the selective service language from the NDAA, and I just look forward to that happening in the next Congress, and we'll support you on that.
I work toward that end.
Okay. Thank you very much. No other members wish to testify on S-1605? Seeing none, this closes the hearing on S-1605. All right. We are now welcoming our witnesses to provide testimony on S-610. Representative Sanchez, Representative Rice, Representative Dingell, Representative Bouchon, Representative Yarmouth, Representative Smith. We're delighted that you're all here. So we'll begin with Representative Dingell.
Thank you, Mr. Chairman.
And make sure your mics are on you.
Is it wired up?
As long as the green light is on, you're all set.
No, I got to turn it. No, I was on. Red light.
Oh, okay. Yeah.
Thank you, Mr. Chairman. I want to speak today in support of S-610, the Protecting Medicare in America Farmers from Sequesters Cut Act. This legislation was crafted in collaboration with my colleagues on both sides of the aisle in the House and Senate, and includes provisions to address several issues related to Medicare payments for providers. As our nation continues to combat the COVID-19 pandemic, this legislation will prevent cuts to Medicare providers from taking effect. Since the beginning of the pandemic, Congress has waived Medicare's 2% sequester to provide relief to all Medicare providers. This legislation will provide additional relief from Medicare sequester cuts. It also prevents any cuts to Medicare and other important programs from occurring as a result of statutory pay-go rules. These cuts have never gone into effect in the past and would be harmful to many programs while we continue to confront this pandemic. Therefore, I'm pleased that we have bipartisan support today to stop these cuts from taking effect. This legislation will allow us to protect Medicare and other federal programs. This bill will also provide substantial relief to healthcare providers. It will increase payments under Medicare's physician fee schedule next year and prevent cuts to Medicare payments for lab and oncology services. These efforts are a continuation of our work to provide support to healthcare providers during the pandemic. I am pleased we were able to come to a bipartisan agreement, once again extending these policies. We came together on this bill because we all agree that it's critical to continue to support providers, especially as we continue to battle the COVID-19 pandemic. Over the course of the pandemic, we've worked to provide over $100 billion in relief to healthcare providers through the Provider Relief Fund and other programs. The critical relief provided by Congress has helped many providers stay afloat during these extremely difficult times when our healthcare services are being stretched to the limit. And I just want to say to all of you, those who think that COVID's over, come to Michigan. Our hospitals are full, not just our small hospitals, but Henry Ford, University of Michigan. These doctors have been on the phone. It makes you want to cry. I'm happy to support extended relief for providers in the Medicare program today. Without congressional action, some healthcare providers would see significant reductions in their January payment. I urge my colleagues to join me in supporting this bipartisan, bicameral legislation today.
Thank you. Representative Bouchon.
Thank you, Mr. Chairman. Today's a little bit of a disappointing day. While I'm a member of Congress, I'm also a doctor. And at a time when our doctors are the heroes on the front lines taking care of our family and loved ones during a once-in-a-century pandemic, leaders of the majority thank them by making them pawns in a high-stakes political game. It's truly disheartening. All of us have been hearing from our doctors back home about the imminent cuts they're facing if Congress didn't act by January 1st, 2022. They've told us how this will threaten seniors' access to care and only make worse the already troubling physician shortage, especially in rural America where I represent, and in urban America also, that we're experiencing in this country. Yet for an entire year, Congress hasn't done anything. We did what Congress does the best, I guess, wait to the last minute. I've been vocal about the need to address these cuts, and I led a letter to leadership with my friend and colleague, Dr. Barra, with over 250 members back in October. But that fell on deaf ears, I guess. And then just last month, Dr. Barra and I introduced H.R. 6020 that would have delayed the 3.75% Medicare cuts for a year to provide certainty for our doctors while Congress works to find a long-term solution to better value their care. This issue has always been bipartisan. I thought it would remain that way. I thought we had worked tirelessly through the weekend to negotiate a deal that an overwhelming majority of members in the House could support. In fact, as of last evening, I thought I would be speaking to you all today in support of the overall bill and this critical compromise on the Medicare provisions to help protect seniors' access to care, which is why I'm not really happy about the situation today. The Democrat leadership poisoned the bipartisan negotiation product for political purposes, once again putting politics before our heroes in the front lines, making our doctors pawns in a negotiation. It didn't have to be this way, and it shouldn't have been this way. The Democrats and the Biden administration, are spending trillions of dollars in Build Back Better, and yet we couldn't find enough time and money to help our providers and protect our seniors' access to care. It's not that I haven't tried. In September, I offered an amendment during the Energy and Commerce markup to the reconciliation bill to address the 3.75% cuts scheduled to hit physicians in the middle of a pandemic, and I agree with my colleague, we are in the middle of a pandemic. On January 1st, those cuts were supposed to go in place, and it failed on a partisan vote. The chairman of the committee, Chairman Pallone, said he would work together with me on this issue, and that he didn't think the markup was the right time, and I understand that. Unfortunately, I never heard from him or his team since. Instead, Democrats in their bill focused on adding $35 billion in cuts to hospitals who serve the most vulnerable patients in 12 states. Those are dish cuts to non-Medicaid expansion states. A provision of their partisan reconciliation bill that was added after our committee considered the bill. Also, the Biden administration needs to get its act together when it comes to the Provider Relief Fund, in my view. There's almost $35 billion left after they finally get the first distribution to healthcare providers since Delta ravaged our communities this summer. The Trump administration was able to set up this fund and get dollars out the door in a matter of weeks. President Biden has been in office since January. It's not acceptable. Supporting our doctors is a bipartisan issue. I want to make that clear. Tying it to something so unrelated like the debt ceiling is not appropriate. I cannot and will not support the legislation tied together. Honestly, Democrats have found a way to force Republican no votes, but doctors and the American people, I think, will see through it. I yield.
Thank you. Ms. Sanchez.
Mr. Chairman, I'm pleased to be here to support the Protecting Medicare and American Farmers from Sequester Cuts Act, introduced by Congressman Horsford and Congresswoman Schreier. Many of you, I've heard from my physicians and hospitals, the resurgence of COVID with the Omicron variant coupled with the Medicare payment change has many of our Medicare providers nervous the next year. This bill is important. It takes important steps to ensure providers are supported as COVID surges again. It provides a transition to new Medicare payments going forward, and it maintains access to care for beneficiaries. First, the bill provides a 3% increase in the Medicare physician payment conversion factor. This will continue a glide path to payment changes that the Centers for Medicare and Medicaid Services, CMS, implemented in the past 2 years. Second, the legislation ensures the Medicare sequester is not going to unduly harm Medicare physicians and hospitals as COVID is resurging this winter. The bill would eliminate the 2% sequester in the first quarter and then eliminate half of the sequester in the second quarter. Lastly, the legislation delays pending Medicare cuts in the laboratory space as well as the radiation oncology model. I know that many of you have heard concerns with, while telehealth extensions are not addressed in this legislation at the moment, flexibilities are not expiring. Therefore, we have more time to collect information, be more thoughtful about the approach of telehealth provisions in Medicare. The American Medical Association, the American Hospital Association, and the Federation of American Hospitals all have noted how difficult the cuts, which are scheduled to take effect on January 1st, would be for providers caring for Medicare beneficiaries. More than 60 million Americans depend on Medicare for their. At the beginning of this month, the Centers for Disease Control announced the first case of the variant had been detected in the U.S. And while COVID cases had been falling, we are now seeing cases after Thanksgiving holiday on the rise. Some physicians and health professionals were facing a year of rather steep payment reductions, and this legislation would ensure that come January, those reductions do not take effect. We have more work to do in the future to ensure both beneficiaries and providers have the strongest possible Medicare program. But this legislation today is a good bill that provides badly needed relief. Finally, this bill prevents a disaster that everyone should want to avoid. Secretary Yellen announced that our country is estimated to exhaust extraordinary measures and cash on hand by December 15th, leading us barreling towards a default if we do not act. This bill provides for expedited Senate consideration of an increase in the debt deal struck by Leader McConnell. It's time to prevent an artificial and unnecessary crisis. I thank the chair and I yield back.
Thank you. Mr. Rice.
Thank you, Mr. Chairman. I was hopeful over the weekend that given the opportunity to come testify at Rules this week, I'd be celebrating a bipartisan Four Corners deal to help our healthcare heroes during this ongoing pandemic. Instead, I'm here to express my deep disappointment that our good faith agreement is being ruined with what my Democratic colleagues know is a poison pill for House Republicans. We all want to provide relief to our healthcare providers, especially in the midst of a pandemic. But tying this assistance to a debt limit increase is a naked political stunt which holds our healthcare providers hostage. There's been no explanation given, no rationale provided. This is a shambles. Why didn't Democrats allow us to do a stand-alone bill to ensure patient access and address healthcare providers' fiscal uncertainty? We did just that in March. Why didn't Democrats prepare earlier in the year for this predictable set of circumstances? How did my Democrat colleagues lose focus on patients and doctors in a pandemic? It appears Democrats focused on a reckless spending spree that most Americans don't even want. That to the point that they forgot what month it is? How can we work together in good faith when our negotiations are constantly undermined by partisanship? The bipartisan Medicaid offset negotiated by my colleagues at Energy and Commerce has been tanked in the Democrats' partisan reckless spending bill. Democrats even tanked the bipartisan retirement bill negotiated by our Ways and Means Chair, Ranking Member, for a partisan reckless spending bill. Now a good faith compromise on a legislative proposal developed through hard work is getting blown up and attached to a poison pill debt limit increase. Protecting patients' access to care and helping healthcare providers during a public health emergency is a bipartisan cause. It deserves congressional action. We could take that action today. The reason we're not is because Democrats have decided to hold patients and doctors hostage to clear the way to continue their reckless and partisan spending spree. This is completely unacceptable and a disservice to our healthcare providers across the country. I yield back.
Mr. Yarmouth.
Thank you, thank you, Mr. Chairman, Ranking Member Cole. It's good to be back before the Rules Committee. There is a long and bipartisan history of Congress doing what is necessary to prevent the statutory Pay-As-You-Go Act from jeopardizing important programs with mindless across-the-board cuts. Congress has enacted bipartisan legislation that has shifted or wiped clean pay-go balances to avert these sequestration cuts more than 30 separate times during the law's, since the law's inception, including 5 times in the last 3 years alone. Even in the wake of contentious legislative battles like the 2017 GOP tax scam, we put the well-being of the American people first and joined Republicans to prevent sequestration. Democrats voted with Republicans to avoid harmful across-the-board cuts, despite our opposition to the reconciliation tax cuts that overwhelmingly benefited wealthy individuals and powerful corporations. The next year, Congress separately wiped the scorecard in the Bipartisan Budget Act of 2018, with 73 House Democrats, myself included, voting with the Republican majority. It's one of the few consistent actions Congress has taken, regardless of who is in the majority. And that's because statutory pay-go has never been an effective tool of fiscal policy. Not only is it ineffective, but it also endangers vital programs, including Medicare, farm supports, social services, and resources for students and individuals with disabilities. Some programs would be eliminated if statutory pay-go is implemented. So it's not hard to see why Congress has always intervened and why we must do so again now. The legislation before you today, the Protecting Medicare and American Farmers from Sequestration Cuts Act, is simply a repeat of legislation we have passed many times before. To be clear, statutory pay-go requirements cannot be changed in reconciliation bills. We cannot do this on our own, and the clock is ticking. Congress has never allowed the statutory pay-go sequester to take effect. Remind you, never allowed statutory pay-go sequester to take effect, and this time should be no different. The sequestered programs have not changed. Congress's support for the programs has not changed. The program's importance in the lives of American families has not changed. And the urgent need for bipartisan action to prevent these senseless and debilitating cuts has not changed. And let me respond to my Republican friends' comments about why we are doing this. And why are we tying this action, which we agree is necessary, to the debt limit? The reason is because Republicans in the United States Senate have decided to take one of the most irresponsible positions that anyone has ever taken in the history of the Congress. And that is, we cannot let the United States government default on its debt, but we are not going to do anything to keep that from happening. That's purely and simply the reason we are doing this today. Thank you, and I look forward to answering your questions and discussing the legislation. I yield back.
Thank you, Mr. Smith.
Thank you, Mr. Chairman. Thank you, Ranking Member Cole. It's a pleasure to be with you all today. We're here because of 2 reasons. One, we had a bipartisan agreement as of 11 o'clock this morning. 11 o'clock to handle a majority of this, and apparently the Democrats, you all decided to lump in everything in the kitchen sink and a couple other toilets and kitchen sinks and everything else. And that's where we are today, without a bipartisan agreement. We had a good faith effort for some period of time, and then you all just flushed it down the toilet. Second reason is the Democrats over the last year has spent trillions of dollars, and under current federal law has created cuts to seniors and the most vulnerable populations. And now you're just trying to file bankruptcy on them. Well, Republicans are here today to protect America's seniors and other vulnerable populations from a series of looming cuts to programs like Medicare. I appreciate that my Democrat colleagues recognize the need for action, especially since a sizable portion of the cuts we are talking about are the direct result. They are the direct result of your $2 billion Biden bailout bill that was passed earlier this year. In other words, part of the problem could have and should have been avoided in the first place. But my colleagues insisting on adding $2 trillion in new spending when they knew it would trigger cuts under the statutory Pay-as-you-go Act. In fact, the $2 trillion Biden bailout bill is the largest tranche. It's the largest tranche of spending ever added to PAYGO in the history of the program. I hear people say that PAYGO has been wiped out every year since it was passed in 2010. Well, why did the Democrats pass PAYGO in 2010? It was the Democrats who made PAYGO a law. If you're never going to abide by it or obey it, why did you pass it? It's the law. It was in effect with a Democrat president, Democrat House and Senate. You tell me. But rather than work in a bipartisan way to address these cuts on the Budget Control Act sequester and Medicare physician fee schedule cuts that are also looming, Democrats have now thrown together a partisan proposal that kicks the can down the road once again. They even tacked on consideration of the debt limit to this mess. There's a much better way to govern. Let's halt these looming cuts, but do it so responsibly. That means covering the cost by cutting wasteful spending and preventing the abuse and misuse of taxpayer dollars. Instead of cutting seniors on Medicare, why don't we rescind Biden bailout dollars that have contributed to the spike in prices facing all American families? Let's ensure benefits and payments are not going to illegal immigrants. Let's put in place common sense work requirements to government assistance programs. And as it relates to the debt limit, Republicans have been clear all year. If Democrats are going to pursue a partisan tax and spending agenda, they can find the votes to raise the debt limit themselves. Republicans are not going to help them pave the road to more spending, more debt, or more giveaways to the wealthy. I made a motion in the Budget Committee a couple months ago saying that if you want to pass this wasteful tax and spending measures by yourself, then you need to amend the budget resolution to raise the debt limit through reconciliation by yourself. I actually made a motion in the Budget Committee to suspend the hearing and to notice it up for a couple days later. Unfortunately, the Democrats on the Budget Committee voted it straight down. If you would have addressed it then, you wouldn't be where you are today. But this party is really good at kicking the can and kicking the can until there's not even a can. I yield back.
Well, thank you very much. It's always great to see everybody. Thank you for coming to the Rules Committee. And I just want to say for the record, to my Republican friends who I respect and admire, I don't really need a lecture in responsible governing from your party. The last time you were in control of the House and the Senate and the presidency, you shut the government down. That's the gift you left the American people as you walked out of here losing the majority. And just for the record, nobody's asking anybody on the Republican side here to vote to deal with the debt ceiling. I wish you would. I mean, when the Republican president was in charge, I voted to help you lift the debt ceiling, even though I disagreed very strongly with the spending you accumulated under tax cuts that went to a lot of people who are well off and well connected. But I thought that defaulting on our debt was an irresponsible thing to do. But in any event, I get where you're all coming from, and you're not going to do it. But that's not what this vote is about. I mean, this is not, you're not voting on the debt ceiling. You'll have to vote on that when it comes back, and I expect that you'll all vote no, because that's what you've been told to do. But this provision we're talking about here is basically it establishes in law a one-time expedited process lasting through January 16th, 2022, to ensure that the Senate can expeditiously pass legislation to lift the debt ceiling to avert financial catastrophe. This is not my idea. I'm not sure it's Mr. Yarmouth's idea or Ms. Dingell's idea. I mean, this is a provision that was negotiated and agreed to by Majority Leader Schumer and Minority Leader McConnell. Now, I don't know whether McConnell changed parties, but I still think he's a Republican. So this is what they have asked for us to send over to them a provision that establishes a process so they can have a vote. And they will vote, my hope is, to not default on our financial obligations. And then guess what? It will come back here. And you get a chance to either do the responsible thing, which is to vote to raise the debt ceiling, or you can vote no. So let's be clear. This is not a vote on the debt ceiling right now. This is a vote on a procedure that McConnell and Schumer have asked us to send over to them. Now, I know it doesn't fit into a nice talking point, but that's the reality. So anybody, the three people who are watching this today, I just want them to understand that that is what this does. And look, here's the good news. You know, the terrible cuts aren't going to go into, I believe, as a result of this, the terrible cuts are not going to go forward. There'll be a doc fix that will move forward. Our colleague, Dr. Burgess, by the way, was very eloquent, I think, was it last week? Yeah, talking about the need for us to act. And we could all argue over, well, we should have done this months ago, whatever. It is what it is. But we're not shutting the government down. We're not going to leave the doctors high and dry. We're not going to let these terrible cuts go into place. It is what the American people want. And we are going to give everybody, Democrats and Republicans, a chance to vote up or down on the debt ceiling. And that is what this is all about. So in any event, wonderful to see everybody. I now yield to Mr. Cole.
Thank you very much, Mr. Chairman.
I apologize the way I look. I'm auditioning for the Phantom of the Opera at the National Theater.
Fortunately, we have medical professionals here to assist you at a moment's notice, Mr. Chairman. Just a couple of questions to my friends, Dr. Bouchon and Mr. Rice. I wanted to ask you about the Medicare-specific provisions in the Rules Committee. Were those provisions subject to bipartisan negotiation and agreement?
Yes, sir. And it's my understanding the four corners had agreed to this, to the Medicare-specific provisions. However, the agreement was my understanding was for a standalone bill to address the cuts, not to be tied to raising the debt ceiling.
Is that your understanding as well, Mr. Rice?
Yes, sir, and I think if we had a vote on a standalone bill, it would pass overwhelmingly.
Okay. If the bill didn't include these other provisions, like delaying the cuts due to pay-go, would you support the bill, Dr. Bouchon?
Yes, of course. We need to do that. We need to fix these draconian cuts that are about to happen to providers before the first of the year.
Same question to you, Mr. Rice.
Yes, sir.
Okay. And let me move to my good friend, Mr. Smith from Missouri. Looking at the process, it appears the Democratic majority is intent to delay the cuts that would come about due to pay-go for another year. Thank you for pointing out when that law was passed and who passed it. Setting up a super cliff for the end of 2022. Do you have any alternative? I mean, this is a big question, and it's one that Congress, in a bipartisan way, honestly, has put off over and over. Do you have any alternative to address the looming pay-go cuts other than just kicking the can down the road?
Absolutely, Representative. We actually offered a piece of legislation back in March to address it, but then, of course, the cuts have even got higher, and we have an additional piece of legislation that we're about to introduce that will turn off the cuts and will allow there to be offsets, and we're providing the offsets of roughly $150 billion to prevent those cuts from taking in effect. And the offsets include reinstating the SNAP work requirements, which will help alleviate labor shortages. Most Americans believe that the social safety net should support work, not replace it. Also, in that piece of legislation, it requires a valid Social Security number to receive the child tax credit. This ensures this tax benefit is going to those who are not violating immigration laws. And this legislation also goes towards reinstating President Trump's public charge rule, and It rescinds unspent money from the Biden bailout bill going to state and local governments, adding up to $150 billion. That would prevent these cuts, but having offsets. And so that's the legislation that we are here and ready to introduce.
So you have a plan. Obviously, any plan's debatable. There are going to be provisions there. People, is there a Democratic equivalent plan?
The only plan that I have seen from the Democrats is to completely postpone it till the end of 2022.
Yeah, I don't consider that a plan. I
Or
mean,
to wipe it
this is how we would do it.
What was passed earlier this spring was just to pass it, wipe it clean.
That's what I thought. Thank you very much. Yield back, Mr. Chairman.
Thank you, Mr. Perlmutter.
Just a couple points. First of all, Mr. Rice, I want to thank you. You called me your Democratic colleague, or you called these folks your Democratic colleague, okay? We are the Democratic Party. We are the Democratic majority. My friend from Missouri comes in here, and I always say this to him, and I'll take off this mask, because I just want to, it's like somebody with their fingers on the chalkboard, not describing, Mr. Raskin has said, call you the Banana Republican Party, but I started calling you all publicans. Just drop the re. So that's just something that is of interest to me. Obviously, the debt ceiling process that we've been asked to undertake, Mr. Yarmouth, is something very unusual. I'm looking at page 10. I'm looking at the proposal. We basically write the rule for the Senate. We write their procedure for the Senate. I mean, we're not setting a debt ceiling amount in this. It's their process. Is that correct?
That's correct. This is really a Ways and Means question, but I feel very confident in saying that that is correct.
Okay. And, I've been sort of on a rant for a whole bunch of reasons today, and one of the
Everyone has those days.
One of the things that I was thinking about on this is that it is a way to circumvent their filibuster, for the purposes of this one raising of the debt ceiling. And so if you looked at page 10, line 4, says it shall not be in order to consider more than one joint resolution under the procedures under this paragraph. What do you think would happen if I changed that 1 to 100?
I think there'd be a lot of Democratic members in the House and Senate who would applaud you.
Okay. What if I changed the single measure authorized to not only will it involve debt ceiling, but just one time, also voting rights? What do you think? Do you think we could maybe get a Democratic passage of
I
that?
think you'd get an
send it to the Senate?
overwhelming Democratic vote for that amendment, yes.
The last thing, it says it sunsets on January 16th, 2022. What if I amended that to be 2032?
I would support that.
Okay. I yield back, Chairman.
Thank you, Mr. Reschenthaler.
Thank you, Mr. Chairman. I appreciate it. And for the second time today, I must say, I think we've thoroughly covered the topic. I just want to thank all the witnesses for coming in. And with that, Mr. Chairman, I yield back.
Thank you very much. Mr. Raskin, Ms. Scanlon.
Thank you, Mr. Chairman. At this point, I'm just really anxious to make sure that the U.S. pays its bills as everyone else is supposed to. We don't need any more financial drama, given the drama we've already experienced from the COVID-induced recession, and we just need to get this done. So I'm looking forward to passing this in whatever way we have to, although I wish the Senate would hold up its end of the bargain a little bit better. I yield back.
Ms. Fishbach.
Thank you, Mr. Chair. And I just have one, as I was looking through the legislation, on page, and maybe, I don't know if anyone can explain this to me exactly, but page 4, under report, and they reference Section 101C of Division N of the Consolidated Appropriations Act. Division N is the COVID relief provision. And so I guess I'm wondering exactly what this provision will do in effect. It changes the dates. And I can maybe find out, because I was trying to pull up the legislation so that I could reference it. But what exactly is happening in that area? Okay.
I actually think you'll agree with it. It just requires the agency to report the amount of money that has been spent. Correct?
Okay, all right. And thank you very much. I just wanted to make sure that that was what it was referencing as opposed to extending dollars into another year. But,
The report.
but I just have to, I do have to just say that I am sorely disappointed that, that the Medicare sequestration is politicized and put into a bill with all of this when it could easily be separated. And I think that it would have made a lot more sense. It would have been far clearer what was happening. And I'm just disappointed that we have made this into a political issue. But with that, I yield back.
Mr. Morelli. Mr. Desaigner, Ms. Ross, Mr. Neguse.
Thank you, Mr. Chairman. Just be very brief. One, I regret that I didn't have the opportunity to partake in the debate regarding the NDAA, and to thank my colleague, Representative Perlmutter from the great state of Colorado, for his leadership with respect to the work that he was doing to add the Safe Banking Act, a critically important piece of legislation to our state and I think to the country. And we all know that he is passionate about this, and we trust that we're going to be able to get it over the finish line. In addition to many other priorities, including the CORE Act, public land provisions that were in the NDAA initially. To that end, I also want to thank the chairman for his advocacy for this committee and its members. And it's certainly not lost on me, and I suspect my colleagues as well, that just how much Chairman McGovern has advocated for the interests of the folks on this committee. I certainly support this legislation. I would just, and I thank the chairman, or excuse me, not chair, the members from Energy and Commerce and from Ways and Means and the chairman of the Budget Committee for their thoughtful presentations. The only thing I would add is to the point that Representative Perlmutter made with respect to the uniqueness of this process by which we are enabling the United States Senate to evade the filibuster on a one-time and only basis. If we ever needed a reminder that the Senate is fundamentally broken as an institution, I think we have it here. And I suspect that perhaps maybe my colleagues on both sides of the aisle could attest to that. The notion that the House essentially has to instruct the Senate by virtue of including it in the law so that we can pay our debts and ensure that the full faith and credit of the United States remains intact, to me is just, it is a reminder why we need to reform the way in which the Senate functions, and I certainly think that that's worth stating. All that being said,
will the gentleman yield on that point?
Of course, happy to yield.
Thank you for pointing that out, Mr. Neguse, because I mean, essentially, we're attempting to legislate around the totally retrograde and obsolete rules of the U.S. Senate, which have become such an obstruction to progress for our country. And the filibuster is at the very least in deep tension with the Constitution, if it's not totally unconstitutional. I mean, every other legislative body or indeed judicial body in the country operates on the principle of majority rule. That's why we've got so many decisions coming out of the Supreme Court, which are 5-4. Could the Supreme Court just adopt a rule saying you've got to get 7 votes in order to strike down a federal statute or a state statute? I don't think so. So the default rule in the Constitution is the majority rules when there is a vote taken. And when we depart from that, it's explicitly stated. It's 2/3 to override a veto. It's 2/3 to convict a president in a Senate trial for impeachment and so on. But otherwise, if it's not stated, then it's a majority, and yet the filibuster rule departs from that, and we're tying ourselves into parliamentary contortions to try to help the Senate deal with the straitjacket that they've put themselves into. I yield back to you.
That's precisely right, and I concur with my colleague from Maryland's analysis as to where we find ourselves. It is odd, to say the least. I mean, the notion that the United States Senate could obviously lift the debt ceiling by virtue of a majority vote, but under their rules, they require a supermajority to get cloture, right, on the vote, and they can't apparently convince 10 Senate Republicans to do so. So as a result, we will now pass into law a procedure that enables the United States Senate to consider lifting the debt ceiling by a majority vote. It is absurd, but it's where we are, and again, I think a reminder of why reform is so desperately needed in the United States Senate.
Well, thank you. I want to thank my colleagues for their comments, and I agree with them, but we know how sensitive people are over the United States Senate, so let's not say any more so people don't get offended and try to derail everything. And let me just say to all the witnesses, you've all been to the Rules Committee before, but I think we made history today. This is probably the shortest panel I think we've had in a long time. So, which is, I think, a testimony to your succinctness, so we appreciate that. And our succinctness up here. So thank you very much. There anybody any more questions for this panel? There are none. You are free to go. So that.
Thank you, Chairman.
That closes the hearing on S610. Now we have to go back to additional testimony on HR 5314 by Mr. Garamendi and Mr. Graves. I know, but we just told Mr. Graves is en route, and Mr. Garamendi is trying to come on. Yeah, we'll give him a couple of minutes. If they're not here, we'll lock the doors and shut off the computers. Why don't we find out? You could test it. You're up. Test it.
Mr. Chairman, occasionally you get lucky and arrive on time. Thank you.
Okay. You may begin. Okay. We need the, okay, ready? Mr. Garamendi.
Thank you, Mr. Chairman and members. I appreciate being here today. I'm here to speak on my amendment, Garamendi 1, to the Protecting Our Democracy Act, H.R. 5314. This amendment repeals the authorization for the appointment of electors after failure to make a choice or on a prescribed day under Section 2, Article 3 of the United States Code, the codified provision for the Electoral Count Act of 1887. Article 2, Section 1 of the U.S. Constitution establishes the Electoral College as the body through which the President and Vice President of the United States are formally elected, and it grants state legislatures the authority to decide how their state's slate of electors are appointed following a free and fair election in their state. However, it also states that Congress may determine when electors are to be chosen and the process through which electors selected by the states ultimately come together and elect the president and vice president. In the wake of the presidential election of 1876, one of the most contentious, well, the second most contentious presidential election in our nation's history, Congress took up its responsibility and set out by Article 2 by passing the Electoral Count Act. This federal law defines how states certify their election results and then uses them to confirm a slate of electors representing the voters' decision in the Electoral College. In the 134 years since the law's enactment, the United States has fortunately experienced continuously peaceful elections and transfers of power. However, this has taken place despite the law and the law's failings, not because of the law. Nothing made this clearer than the Trump administration's reaction to the 2020 false claims that the election was somehow stolen and ultimately culminated in the deadly and devastating events of January 6th, with the insurrection at the U.S. Capitol that threatened the lives of members of Congress and then Vice President Pence. You were all there, as was I. Former President Trump and his advisors specifically targeted and sought to exploit the vulnerabilities in the Electoral Count Act to try and hold on to power, despite the clear results of the national popular vote and the Electoral College vote. Mr. Chairman, the fact that our Speaker of the House of Representatives and then Vice President Pence, all of the members of Congress, and came back into the House chamber following the insurrection to formally confirm the Electoral College count, we did this despite the threats made against our lives. This should be a source of immense pride and satisfaction to Americans. Tragically, President Trump's effort to exploit loopholes in the Electoral Count Act of 1887 did not end on January 6th. Over the last year, Republican state officials have been working to build on the big lie by enacting state laws to allow partisan lawmakers to reject the will of the voters and undermine American democracy. Such efforts, seeking to allow state legislatures to exploit the ambiguities in the Electoral Count Act as early as the next presidential election, 2024. It is set up in such a way that they can simply choose their preferred state of electors regardless of the outcome of the election in that state. These dangerous actions undercut the public trust that comes from being an elected official in what we like to believe is the world's greatest democracy. Simply put, the poorly written 19th century law is failing us and needs to be modernized for a world where, sadly, Americans can no longer count on some craven elected official in some state doing the right thing. Congress must act now to reform this outdated law to ensure that no state legislature controlled by any party, Democrat, Republican, Green, or any other party, can subvert a presidential election by ignoring the will of the American people and, most importantly, the will of the citizens in that state. For a few of the more significant examples of the law's weakness can be found then in Section 2, Title 3 of U.S. Code, which my amendment would repeal. This section, brief as it is, states, quote, whenever any state has held an election for the purpose of choosing electors and has failed to make a choice on the day prescribed by law, The electors may be appointed on a subsequent date in such matter as the legislature of that state may direct. I need to say that again, because this is where the risk is. Whenever a state has failed an election for the purpose of choosing electors and whenever a state has held an election for the purpose of choosing electors and has failed to make a choice on the day prescribed by law, the electors may be appointed on a subsequent day in such manner as the legislature of such state may direct. The legal scholarship is clear that the original intent of this section was to ensure the timely certification of electors in event of such catastrophic events as war or natural disasters, which was in fact the case in 1886-87. However, the lack of specificity of this provision simply creates the potential for abuse, such as a partisan state election official refusing to count or to certify the election results on purpose, thereby allowing this particular clause to come into effect. The legislature could then simply put aside the votes, even though they are there, even though they could have been counted, even though they could have been certified. Simply put aside those votes and then give to the legislature the power to select the electors. This outdated section of the Electoral Count Act does more to threaten the electoral process than it does to safeguard it from the legitimate delays or disruptions that might occur, such as a natural disaster in that state. This is especially true as our nation has repeatedly proven its ability to hold timely and fair national elections despite such circumstances as wars and pandemics. Specifically, the law does not specify what qualifies as a failure of a state to make a choice and includes no reference to the mitigating circumstances in which it would be appropriate to invoke the law. Additionally, it grants wholesale authority to the state legislatures to determine how electors would be selected in, quote, such manners as they choose, without the need to account for the votes that have been cast by voters in that state. In short, there is no requirement in the statute that prevents rogue state legislators from artificially determining the election's that the election failed and subverting the legitimate choice of the voters in that state by instead picking a state of electors of their own choosing. If this were to take place, and there's every indication that it could and that there are plans in place to do this. There are plans in place to do exactly this. So, what are we to do? Well, if it were to happen, it would be the end of the democratic process in this republic, the United States of America. That's why my amendment seeks to repeal this specific section of the Electoral Act law. Members of this committee, democracy is fragile. Whether you're a Democrat, a conservative, a progressive, a Republican, conservative, or progressive, maybe there are progressive Republicans, but every single one of us took an oath to the Constitution. Every one of us did. And this is what is at stake. Are we just simply to stand by when we have evidence today that a plan is underway to use this section of the law? You know it. You read the newspapers. We all know what's going on. Are we to stand by and allow our democracy to be subverted? If we were to enact this repeal of this section, the opportunity to abuse the democratic processes of this nation that have carried us all this way would not exist. And our democracy could go on, not without any trouble. There's always going to be trouble. But this is a moment This is a moment in this Congress when we know that there is a plan afoot to use this section to subvert an election. So, it's up to us. What are we to do? I would ask that you would make this in order. And with that, I yield.
Thank the gentleman for his remarks. The gentleman from Louisiana, Mr. Graves, is recognized for his comments.
Thank you, Mr. Chairman. Mr. Chairman, I appreciate the opportunity to be here, and I want to state coming out of the gates that there are a number of things in this legislation that I would support. And certainly the larger objective of protecting our democracy is something that I hope all 435 of us support. And going through this bill the other night, I couldn't help but really reflect on Division C. Title is Defending Elections Against Foreign Interference. Title 13, Reporting Foreign Interference in Election. Title 14, Eliminating Foreign Interference in Elections. Mr. Chairman, according to the Center for Immigration Studies, a 2019 analysis, there are 30 million people that are in our country illegally right now, including their dependents, 30 million. Quick math, we each represent about 750,000 people. If those 30 million people were in their own state, that would be 40 congressional seats, because under the way that we currently do apportionment, those people, regardless of the fact that they're citizens of a different country, they count toward apportionment. So let me say it again. If those 30 million people were in their own state, that would represent 40 seats in Congress. It would represent 40 electoral votes. Mr. Chairman, if we're worried about foreign interference in elections, specifically when you go through, the state of California today apparently has 4 more congressional seats than it's due, entirely attributable to citizens of other countries. The states of Texas, has 3 additional seats. New Jersey, Florida, and New York each have 1. Now, on the flip side, the states of Alabama, Idaho, Michigan, Minnesota, Missouri, Ohio, Pennsylvania, Tennessee, West Virginia, and Rhode Island have all lost congressional seats because of the extra, and I want to use that word again, the extra congressional seats that the states that I mentioned, California and Texas and New Jersey, Florida, and Tennessee, New York have. So some states have lost seats due to
Including
citizens.
California.
No.
Yes, we lost a seat.
You lost the seat, but you have 4 extra seats that are not due to the state because of citizens of America.
That's not true.
All right, Mr. Graves, it's Mr. Graves' time, please.
So I'm happy to share the study with my friend from California. I actually work on a lot of bills and amendments with.
Gentlemen, address the dais.
So, Mr. Chairman, let me translate this another way. If you're a citizen of the state of California and you're voting for president, your vote is effectively worth 108%. It's not worth just 1 vote. It's worth 108% of a vote. Conversely, if you're a citizen of Alabama, your vote's only worth 90%. Because states have lost congressional seats because of people that are here illegally, and states have gained. These are people that are voting for president of their own countries, yet they're influencing. They're foreigners influencing our elections. So Mr. Chairman, let me run through these numbers again. California, if you vote in California, your vote's worth 108%. If you're in New York, 104%. In New Jersey, 107.6%. However, if you're a citizen of Michigan, it's only worth 93%. Pennsylvania, 95%. Alabama, 90%. Idaho, 80%. Minnesota, 91%. Missouri, I think, is the same. Tennessee, 91%. West Virginia, 92% or 93%. And Rhode Island, 80%. Mr. Chairman, I have 2 amendments. And what they do is number 59 effectively just says that for purposes of the Electoral College, citizens, or people that are here illegally, non-citizens that are here illegally, they can't affect the number of electoral votes that a state gets. Because that undercuts or it overweights the votes of actual Americans, the people that are trying to determine their leader. If we're concerned about foreign interference in elections, as this bill does, these should be easy amendments to accept. The Second Amendment, number 60, says that the presence of people here illegally shouldn't cause any impact to underweight or overweight the vote of an American for president. So, Mr. Chairman, I think that these two amendments are entirely compatible with the bill. I'm very disappointed this legislation has not gone through the committees that it was referred to, including a committee that I serve on, that this was just brought directly to Rules Committee and going to the floor, this 175-page bill. But let me say it again. If we're concerned about foreign interference in elections, let's put this on steroids. Let's say that Vladimir Putin sends in millions of people to come infiltrate the southern border, which apparently isn't very hard, and he wants to strategically put them in states, or maybe even you're president of the United States and you want to strategically deploy these illegal folks around our country, you can manipulate the outcome of the elections. This is about election integrity, and it's about making sure that my vote for president of the United States counts the same amount as my friend from California, Mr. Garamendi's vote for president. So I urge adoption of these amendments. I'd be happy to answer any questions and yield back.
Gentleman yields back. I appreciate both of you being here to testify today. The section of the bill that your amendment addresses, Mr. Garamendi, just want to strike that section of the 1877 law?
Yes, my amendment would strike that section of the 1887 law.
Okay, and the reason being you don't want to give the discretion to a legislature as to how to seat the members of the Electoral College.
Yes, the way the law is written, it's open to any interpretation. Once that date of certification is passed, the power then passes to the legislature in any state to do anything it wants to do about the electors. They can select their own electors. They could also go back and select the legitimate electors. It's just wide open for abuse. And therefore, we would strike it. And in fact, it's not necessary in a modern America. In 1887, I believe it was one of the Midwestern states, had I think it was a flood, and was unable to perform. And that created a significant turmoil in that election.
Mr. Graves, are you objecting to how we do the census, or are you objecting to the enumeration? So this is sort of the enumeration clause of the Constitution. Are you proposing a constitutional amendment? Is that what you're doing?
Mr. Chairman, I think that you can entirely separate this from the census process. While I do not agree that the census should count non-citizens, I don't agree, and I want to be very clear on that. That's not what our amendment addresses, because this bill addresses foreign interference in elections. That's what our bill does. Our bill pertains to the Electoral College portion of it. And if you disagree with me that my vote should count the same as yours, that my vote should count the same as Mr. Garamendi's, that any citizen of any state should count the same for President of the United States as others, then there shouldn't be any objection to this amendment. If you're saying that there should be overweight by a vote from a citizen of California, then you should oppose it. I don't agree that that's fair.
So your real complaint is about the Electoral College.
Let me say it again. I disagree, but we can just put that aside for a minute. I disagree with the way the census is done, but that's what our amendment addresses. It's only the Electoral College. Yes, sir.
Are either of you familiar with the Wyoming rule, the proposed change to our statute of how the number of people that we would each represent? So the Wyoming rule is the state with the fewest number of people would be the least common denominator. So we would all wheel off, in this instance, Wyoming, which has about 560,000 people. So each of us would represent a district with 560,000 instead of it. Right now, I think Mr. Neguse and I are around 900,000. But we would all, it would obviously increase the number of people in the Congress, in the House of Representatives. Mr. Graves, Mr. Garamendi, have either of you thought about that? And then I'll yield back to the chair and to Mr. Cole.
Oh, I can assure you, Californians think about that all the time.
Well,
All the time. We got 40 million people in our state. Wyoming has maybe not even 1/10 of that. And they also have 2 senators. Oh, we think about it all the time.
It doesn't really answer your question, Mr. Graves, but it does sort of soften it to the point where people aren't losing, members of Congress.
Well, Mr. Chairman, I'd be happy to discuss it with you. I think with 435 people, this is already a pretty big group of folks, unwieldy body. I'll just say if Cajuns count twice, then I'm in.
Thank you. I yield back to
Mr. Cole.
No question, Mr. Chairman.
Ms. Scanlon. Dr. Burgess. Mr. Morelli.
Just for clarification, you keep saying overcounting and how many people live in California, Mr. Garamendi, since you happen to be here?
We're approaching 40 million.
40 million. How many electoral votes do you have?
Presently,
Yeah.
53 plus 2, 55.
When you compare that, Wyoming has 3 and they have 400,000 people. How do you consider that California is overrepresented in the Electoral College?
Sure, it's a great question. So as you know, the founders had a very intentional approach on how they set up the government, to where each state in the Senate had 2 representatives, and each member of the House was represented based on a percentage or a portion of the population. They didn't intend to have that second number. So these are 2 factors. One of them is each state gets 2. The other one is based on population. It is not designed to distort the second one, and that's exactly what this process does. That's what our amendment focuses on. It focuses on that second factor that entirely distorts or outweighs or underweighs the vote of a citizen of this country for President of the United States, contrary to what the founders intended. 2 separate steps.
Would the gentleman yield, because I
I'd be delighted to
appreciated,
yield,
I
'cause I really
appreciated
don't
Mr.
understand the
Morelli's line of questions, and that sort of goes back to this Wyoming rule. And the reason I say that is initially under the Constitution, each one of us represented 30,000 people, okay? So I don't know how many, with 300 million people should be able to do the math. I don't know, it's 10,000 of us or something like that. But what it does is it continues to give further power to the smaller the states when we cap the population. So a California that you're complaining about because of undocumented aliens, or because is really harmed, loses power to a small state like Wyoming on a per capita basis.
Mr. Chairman, if I may, you're talking about something that was very deliberate and intended to give each state equal representation. That was part of the balance of the initial negotiation. The second one is based on population. That's the one that our amendment focuses on.
Right, and
I'm sorry.
I yield back to the gentleman.
Yeah, no. But the founders were equally direct about it. It's inhabitants is, I believe, the phrase that they use, not citizens, it's inhabitants. So why would you look at one portion of it and say, let's be strict in our view of what the founders wanted and then ignore the other half of it?
So well, it's interesting.
So it's like heads I win, tails you lose?
At some point it might, but Mr. Morelli, it's a good question, but let's go ahead and play this out. Let's say that Vladimir Putin decides that he wants to come in and manipulate elections and sends all these people in through our southern border, as we have captured people from Russia at our southern border. Let's say that he wants to do it and he directs them to go to certain states. Just putting this on steroids, and yes, a far-fetched story, but just trying to do it for illustration purposes, then that would be foreign interference in elections. These are people that are voting for president in other countries. And we're
So I have
allowing them
to-
to determine that you can overweigh or underweigh votes of Americans for president of the United States. That's foreign interference in elections.
So respectfully, your fear is that a foreign leader would push people into the United States, direct them which states to reside in, so that the 10-year census, those who aren't citizens would add to the electoral vote count of those states, and you'd be able to determine which state, I mean...
No, sir, Mr. Morelli, that's what President Biden's doing with the distribution of illegal immigrants in the country today. What I'm talking about is the 30 million people that are in this country right now illegally, that according to the Center for Immigration Studies, in their 2019 report, has identified the states that benefit and the states that are harmed by this distribution of people that are here illegally, and how it underweights or overweights.
But again, the Constitution says inhabitants.
Yeah,
It doesn't, I mean, so how is this not
So I just want to make sure, I understand. So you all agree that the citizens of California should get additional votes, additional weight of their vote for president of the United States, and the smaller states, or the states that I referenced, Alabama, Idaho, Michigan, Minnesota, Missouri, Ohio, Pennsylvania, Tennessee, West Virginia, and Rhode Island should not. They should be underweighted or undercounted. I just want to make sure.
The small states that you've suggested, I'm happy to yield in just a moment, but the smaller states that you've mentioned, on a per capita basis, have more electoral votes by virtue of the United States Senate. So, but if we were to accept that the founders wanted to do that, why would we? I'm not trying to suggest that it's my opinion on whether people who are documented, undocumented are allowed under the census to be counted. The founders said it. It's not, is there a dispute about that?
Mr. Morelli, you have two criteria. One criteria distributes electoral votes strictly based on 2 votes per state. The second one is based on population.
Population.
I'm
But
talking about the population one.
Yeah, and the population is described by the founders as inhabitants.
So I'll say it again. If you agree.
Well, do you agree that it's fair to Wyoming to have 3 electoral votes relative to their population versus state of New York or California?
Do I agree with the way the founders balanced the
You
governance?
are what the founders want.
Absolutely.
Would the gentleman,
Absolutely.
You only want to follow the things that the founders said that you agree with.
I agree with what the founders have set up in regard to having a balance and allowing each state 2 votes and then having a population
Okay, and I
component.
accept that.
was
And the
an
founders
agreement that
also
the
said
states
that
negotiated.
inhabitants are how it's determined. I mean, I guess we figure out
So
which things.
someone who gets to vote for president of a foreign country should also be able to influence the votes for president of their state, the electoral votes?
Well, I think we're going to keep going around, but the only thing I'll say is, if I accept that the founders wanted the Senate to have 2 votes and the electoral votes to be counted that way, which I do, I also accept the fact that the founders described how the census should be done, and that's by inhabitants, and I'm happy to yield to, I know that.
Thank you,
both gentlemen.
Mr. Morelli. Well, let's start with this. I think we could probably agree, or at least I hope you would agree, that the Electoral College itself is a completely antiquated, obsolete institution. We get rid of it, and we should have a national popular vote for president, including just U.S. citizens. Would you agree with that?
No.
Why not?
Because I like the balance.
You like
that
the
founders
disproportion
struck.
that's built into it,
I like
right?
The balance.
Okay.
No, what it does, as you well know, it was a negotiation among the states that tried to establish a balance between smaller and larger states.
All right, can I disagree with you about that?
Please.
Okay, I believe you're right about the U.S. Senate. There's no doubt the Connecticut Compromise was designed to make sure that the smaller states like Rhode Island and Connecticut and North Dakota or what have you would have 2 senators like California and New York and Florida and Texas and Michigan. Okay, that's the Senate. We only have 1 president. We only elect a president one way. Either we're going to elect the president by virtue of 1 person, 1 vote, the way we elect governors, U.S. senators, representatives, and mayors, or we're going to have this totally jerry-rigged, bizarre system where we get people who lose in the popular vote who win in the Electoral College. But obviously, we're not going to agree on that. But 2 of our last 5 2 of our last 6 elections gave us the loser in the popular vote as President of the United States.
Mr. Raskin, the process that you just abused is the very process that we use to make laws in this country and have for our entire existence.
Wait, I'm talking about the election of the president.
But you just abused the fact that you have a system that allows 2 votes or 2
No, I did. On the contrary, you misunderstand me. I said for the Senate, that is precisely what the Connecticut Compromise, the so-called Great Compromise, was about. Then the election of the president was derivative of the Senate and of the House. And the way you stated, we say we'll take the 2 senators from each state and we'll take the representatives and we'll add them together and that'll become the electors. But there's no rhyme or reason to that because for the Senate, the state's representatives in the Senate get to go there, but we only have 1 president. It's not like that all of the small states get a mini president. We just get 1 president who could be from a big state like Ronald Reagan or a small state like Joe Biden, right? But why don't we elect that person by a popular vote? But we're obviously not going to agree on that. But that is the principle of democracy. That's a majority rule principle. Now, if we're going to depart from a majority rule principle and we're going to sacralize what existed at the time of the founding, which included the 3/5 compromise, by the way, that is the counting of 60% of the slaves for the purposes of inflating the congressional delegations from the southern states, but we got rid of that through a civil war and the Reconstruction Amendments. But if we're going to sacralize what's left of it, then Mr. Morelli's point seems to me exactly right. Why would we deify and valorize the electoral disproportion built into the Electoral College where small states get their numbers inflated, but then not accept the counting of the whole persons of the states counted, which is provided for? Wait, put it another way. At what point did our interpretation of the founders go wrong in terms of the counting of full persons?
Mr. Raskin, this has nothing to do with small states or large states. What happens if all 30 million people were in Alabama?
Well,
no, but I agree with you. But would you agree? You understand the Supreme Court ruled on the point you're making.
The population criteria. It distorts it.
Can we just speak one at a time?
Okay, here's my last point.
Yeah, and just we wrap
This is my
up.
last point because it's important to know you are aware that the Supreme Court ruled on this question with respect to the census, and your position lost on that, right?
With regard to the census, and I'll say it again, I disagree. I disagree that the citizen of another country should be able to vote for the president of their country.
Take it up with the Supreme Court.
And influence.
Take it up with the Supreme Court that your party gerrymandered.
Somebody who's here
through the
illegally.
filibuster.
Somebody that's here illegally should be able to influence who the president of the United States is. Think about that.
Tell it to Justice Roberts.
Time back.
All right, I yield back.
I just want to, I appreciate, this is fun, and I didn't mean to start all this entirely, but I'll only say this, that I guess my point was this: you can change the Electoral College, you could change up the makeup of the United States Senate, you could change the makeup of a lot of things, including how we do the census and arrive at inhabitants, but it takes constitutional amendments or it takes changes beyond what you can do here. I don't, but anyway, I'll yield back because I think that was the point I was trying to make.
Mr. Reschenthal.
Mr. Chairman, I feel like I'm back in political science in college. It's an interesting debate. I actually was enjoying it. Because I feel like we've exhausted this, I'm going to yield back, but I was enjoying the discussion. And I'll offline counter Mr. Perlmutter on the Wyoming rule, but for sake of time, we'll move on. I yield back.
All right, let me see, Ms. DeSaulnier, Ms. Ross,
No questions, I yield back.
Mr. Neguse. No, I'm sorry, Ms. Fishbach. Mr. Neguse.
Just very brief, I can't resist at least a little colloquy with my friend, Mr. Grace from Louisiana. I guess I'm struggling with understanding how your amendment, in particular number 60, can be legitimately divorced from how individuals are counted under the census. So the language of your amendment, notwithstanding any other provision of law, citizens of a foreign country may not cause the vote of any citizen of the United States to have a greater or lesser impact on electing the President of the United States through their illegal presence in the United States at the time of the census. So in effect, to effectuate your amendment, you are proposing not to count those individuals for purposes of the census, which then is used to determine the Electoral College.
Actually, I think the pivotal provision here is greater or lesser impact on electing the president. It remains silent in terms of apportionment for congressional seats.
Sure, I understand that you're saying for purposes of congressional seats, but at the end of the day, those totals are used to inform the Electoral College totals. So I understand maybe what you're saying is for purposes of congressional redistricting, you would concede, at least for purposes of this amendment, to allow all individuals to be counted, but for purposes of the Electoral College, you're suggesting that when the census is done, they shouldn't be counted. And my point would just simply be to restate a point that Representative Raskin made. This issue has been litigated over the course of many years, and I'll quote from the Usech versus Trump district court decision, a decision by a district court judge in Maryland, November 20th of last year, a year and a half ago, and the first two sentences. Since the first census in 1790, every census and apportionment has accounted for the total persons in each state without respect to immigration status. And until July 2020, no branch, none, of the federal government had ever taken the position that non-citizen residents of the United States could lawfully be excluded based on their immigration status from the apportionment base. So I think the position you're articulating, it could be fairly described as a radical one, but in any event, it's been rejected by the courts, and I, like Representative Raskin, would encourage you to pursue that means to the extent that you'd like to,
Mr.
pursue these amendments further.
Neguse, I appreciate it, and I just want to make note that now that we're at 30 million people here illegally, that is effectively 10% of our nation's population, maybe it's become a crisis that we should address, rather than continuing to allow foreigners to interfere and influence who the President of the United States is.
Well, Mr. Chairman?
Yes, well, I mean, he's at the time.
Would the gentleman yield for one moment?
Reluctantly, because the chairman, yes, of course.
Just with your indulgence, Mr. Chairman, just two quick points on this. One is, I agree with you that we have a real problem of foreign influence being exercised through money in our political process, and I've got legislation on that I would love to have you join me in, called Get Foreign Money Out, because as President Obama predicted, the Citizens United decision, by allowing corporations to spend freely in our politics, opened the floodgates, as President Obama said, to foreign money coming through domestic subsidiaries of foreign corporations or directly through corporations. So that's a very serious problem that we've seen over the last several election cycles. I'd love to have you.
I'd love to work with you on a
Good.
bill.
And I will talk to you about that. But just on this other point, one, I would recommend that you check out the debate that took place between the Republicans and the Democrats and Abraham Lincoln when he was a Whig.
Is this on YouTube?
Against the Southerners. Well, unfortunately not on YouTube, but it should be. But Lincoln very strongly championed the right of non-citizens not only to be counted in the census, which is constitutional, alas, from your purposes, but also for the right of non-citizens to vote. And if you look at what happened in the election of 1860, he was roundly attacked because of Irish and German immigrants voting for him, but he supported a policy that they called declarant suffrage, which is if you declared that you would become a citizen at the first available opportunity, a lot of states chose as an exercise of federalism to enfranchise those people. And the Southerners said that all of these foreigners are coming in with anti-slavery ideas, and they are promoting abolitionism, and the North said, we need people in the country, we have labor shortages in the country, we want them in, and if they're going to become citizens one day, they should be able to start voting. So just to be aware that it was the founder of your party who actually was the one who championed not just counting non-citizens, which is a constitutional mandate, but allowing them to vote, at least in local elections.
And Mr. Raskin, I'm happy to go back and look and talk about things that happened a little while ago. But I think the crisis is right now. I think that this issue is very serious, and I think it is consistent with the objectives of this bill by preventing foreign interference in elections, and I hope that we can work together on that issue.
Good deal.
I yield back.
And we all share the goal of making sure that there's not foreign interference in our election. I wish we all shared that in 2016 when Putin did interfere in our election, but I won't go there. Anyway, I want to thank all of you for any other questions.
I just think we should also go after the French who interfered in the elections in the late 1790s too. I mean, it's. And let me make sure, I share your concern, I really do, but just for the record, as an old historian, other countries have been interested in American elections since the very beginning and have been interfering in them, or attempted to, since the very beginning. So it's something we ought to always
And
be
we have-
vigilant about. I don't.
And unfortunately, we have in other elections, foreign elections.
As
too.
we have
Right,
indeed,
which is-
yes. I
So we all ought
remember
to,
President Obama interfering in the Brexit election
we all ought to
very
be-
directly.
we all ought to mind our own business. And anyway, seeing no other questions, this closes the hearing on HR 5314. Thank you very much.
Could I thank, though, our witnesses for generating, a thank you, and our participants for interesting debate.
Thank you. So before we get to today's rule and any motions, I want to recognize our clerk, Jessica Saab. She's a familiar face to many of us, and she's often calls the roll at our meetings, but she has done so much for this committee and all of us behind the scenes to make things run smoothly. In fact, counting an internship with former Chairwoman Louise Slaughter, who's watching us right now, and she has been with us for nearly 5 years now. And today, she's let us know that she's going to be leaving at the end of the year for a new opportunity. And Jessica, I want to recognize your years of service here. I want to thank you for your work. I want to wish you all the best in moving forward, sentiment that I know is shared by members on both sides of the aisle, and and you'll always have a home here. So thank you so much for everything. So at this time, the chair will entertain a motion from the distinguished gentleman from Pennsylvania, Ms. Scanlon.
Thank you, Mr. Chairman. I move the committee grant H.R. 5314, the Protecting Our Democracy Act, a structured rule. The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Oversight and Reform or their respective designees. The rule waives all points of order against consideration of the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of Rules Committee Print 117-20, modified by the amendment printed in Part A of the Rules Committee report, shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule provides the following debate: each further amendment printed in Part B of the Rules Committee report, not earlier considered as part of amendments en bloc pursuant to Section 3, shall be considered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, may be withdrawn by the proponent at any time before the question is put thereon, shall not be subject to amendment, and shall not be subject to a demand for division of the question. Section 3 of the rule provides that at any time after debate, the chair of the Committee on Oversight and Reform or her designee may offer amendments en bloc consisting of further amendments printed in Part B of the Rules Committee report not earlier disposed of. Amendments en bloc shall be considered as read, shall be debatable for 20 minutes, equally divided and controlled by the chair and ranking minority member of the Committee on Oversight and Reform or their designees, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendments printed in Part B of the report and amendments en bloc described in Section 3 of the resolution. The rule provides one motion to recommit. The rule provides for consideration of S-1605, the National Defense Authorization Act for fiscal year 2022, under a closed rule. The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Armed Services or their respective designees. The rule waives all points of order against consideration of the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of Rules Committee Print 117-21 shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule provides one motion to commit. The rule provides that the chair of the Committee on Armed Services may insert in the congressional record not later than December 10, 2021, such material as he may deem explanatory of S-1605. The rule further provides for consideration of S-610, the Protecting Medicare and American Farmers from Sequester Cuts Act, under a closed rule. The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Ways and Means or their respective designees. The rule waives all points of order against consideration of the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of Rules Committee Print 117-22 shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule provides one motion to commit. Finally, the rule provides that at any time through the legislative day of December 9, 2021, the Speaker may entertain motions offered by the Majority Leader or a designee that the House suspend the rules with respect to multiple measures that were the object of motions to suspend the rules on November 30th, December 1st, or December 8th, 2021, and on which the yeas and nays were ordered and further proceedings postponed. The Chair shall put the question on any such motion without debate or intervening motion, and the ordering of the yeas and nays on postponed motions to suspend the rules with respect to such measures is vacated. I yield back.
Thank you. You heard the motion from the gentleman from Pennsylvania. Is there any discussion or amendment? Mr. Cole.
Just two things, Mr. Chairman. First, I had intended to move Comer 41, but I understand it's been made in order, and I wanted to thank the gentleman for doing that. Second, I just wanted to note for the record that when you announced sadly that Jessica will be leaving us, every member on our side applauded, even though we have never won a single vote in which she's been the teller, because we are absolutely confident that every vote has been precisely and exactly and accurately recorded. So with that, I yield back.
Thank you. Are there further amendments? Dr. Burgess.
I have an amendment to the rule, and it moves the committee provide for division of the question for the House amendment to S610.
You heard the gentleman's amendment. Any discussion?
Well, just further,
yeah.
I was going to say that we shouldn't link the bipartisan goals of delaying these Medicare cuts with the highly partisan effort to wipe the pay-go scorecard to facilitate the continuation of this spending brought on by the current majority. We should be focusing on the items where we can agree instead of using this committee to combine items that have no business being considered under the same bill, and I urge support of my amendment. I yield back.
Thank you. And as you know, we're trying to make sure that the government keeps running and that we don't default on our obligations, and this is, I think, the only way to proceed. But we are going to help our doctors, and that's important. And you mentioned that a few days ago at our last meeting. So the vote is now on the Burgess amendment. All those in favor say aye.
Aye.
Opposed, no. No. Being the chair, the noes have it.
Ask for a roll call.
A roll call has been requested. Clerk will call the roll.
Mrs. Torres. Mr. Perlmutter. No. Mr. Perlmutter. No. Mr. Raskin.
No.
Mr. Raskin. No. Ms. Scanlon. No. Ms. Scanlon. No. Mr. Morelli. No. Mr. Morelli. No. Mr. DeSaulnier.
No.
Mr. DeSaulnier. No. Ms. Ross.
No.
Ms. Ross. No. Mr. Neguse. Mr. Neguse. No. Mr. Cole.
Aye.
Mr. Cole. Aye. Mr. Burgess.
Aye.
Mr. Burgess. Aye. Mr. Reschenthaler. Aye. Mr. Reschenthaler. Aye. Mrs. Fishbach. Aye. Mrs. Fishbach. Aye. Mr. Chairman.
No.
Mr. Chairman. No.
Clerk report the total.
4 yeas, 8 nays.
Amendment is not agreed to. Further amendments.
Mr. Chairman, I have
Dr.
an
Burgess.
amendment to the rule. I move the committee make an order amendment number 6, offered by myself. This amendment strikes Title 7, Subtitle A from the bill and replaces it with Section 2 of S 587. This amendment would remove the 9 reasons that a president must choose to terminate an inspector general and replace them with a requirement that the president or the head of a federal agency provide a written explanation to Congress for the removal or suspension of an inspector general.
You heard the gentleman's amendment. Any discussion? Hearing none, the vote is on the Burgess amendment. All those in favor say aye.
Aye.
Opposed, no. No. Being the chair, the noes have it.
Mr. Chairman, I would request you record a
Clerk
vote.
will call the roll.
Mrs. Torres. Mr. Perlmutter. No. Mr. Perlmutter. No. Mr. Raskin. No. Mr. Raskin. No. Ms. Scanlon. Ms. Scanlon. No. Mr. Morelli. No. Mr. Morelli. No. Mr. DeSaulnier.
No.
Mr. DeSaulnier. No. Ms. Ross.
No.
Ms. Ross. No. Mr. Neguse. Mr. Neguse. No. Mr. Cole.
Aye.
Mr. Cole. Aye. Mr. Burgess.
Aye.
Mr. Burgess. Aye. Mr. Reschenthaler. Aye. Mr. Reschenthaler. Aye. Mrs. Fishbach. Aye. Mrs. Fishbach. Aye. Mr. Chairman.
No.
Mr. Chairman. No.
Clerk report the total.
4 yeas, 8 nays.
Amendment is not agreed to. Further amendments.
Mr. Chairman, I have another amendment.
Dr. Burgess.
Amendment to the rule, and move the committee make an order, amendment number 11, offered by myself. This amendment would require any congressional subpoena to be approved by both the chair and ranking member or 2/3 majority of the committee or subcommittee issuing the subpoena. Mr. Chairman, as you know, subpoenas have become more politicized recently, and it appears the majority party is seeking contempt of Congress for anyone who doesn't immediately comply with a subpoena. Currently, most committees simply require consultation with the ranking member of a committee and/or a vote by a majority of the committee, with at least 1/3 of the members being present. By requiring, with this amendment, approval by both the chair and the ranking member, or at least 2/3 majority of the committee, subpoenas would be less likely to be used as a partisan attack. So I urge this amendment to be made in order and adopted. I yield back.
You heard the gentleman's amendment. Any discussion? Hearing none, the vote is on the Burgess amendment. All those in favor say aye.
Aye.
Opposed, no. No. Being the chair, the noes have
We
it.
won that on voice, but I'd ask for a recorded vote.
Clerk will call the roll.
Mrs. Torres? Mr. Perlmutter? No. Mr. Perlmutter? No. Mr. Raskin? No. Mr. Raskin? No. Ms. Scanlon? No. Ms. Scanlon? No. Mr. Morelli? No. Mr. Morelli? No. Mr. DeSaulnier?
No.
Mr. DeSaulnier? No. Ms. Ross?
No.
Ms. Ross? No. Mr. Neguse? Mr. Neguse? No. Mr. Cole?
Aye.
Mr. Cole? Aye. Mr. Burgess? Aye. Mr. Burgess? Aye. Mr. Eschenthaler? Mr. Eschenthaler? Aye. Mrs. Fishbach? Aye. Mrs. Fishbach? Aye. Mr. Chairman?
No.
Mr. Chairman? No.
Clerk report the total.
4 yeas, 8 nays.
Amendment is not agreed to. Further amendments? Mr. Reschenthaler.
Thank you, Mr. Chairman. I appreciate it. Mr. Chairman, I move the committee make an order amendment number 31, offered by my good friend, Mr. Bergman of Michigan. This amendment prohibits immediate family members of the president and vice president from accepting gifts, payments, or other things of value from a foreign nation. Mr. Chairman, the legislation before us today already prevents the president or vice president from accepting foreign payments, but this common sense amendment goes even further by ensuring no immediate family members can receive foreign gifts either. It's in the best interest of our nation to ensure our executive branch remains free from foreign influence, and extending the prohibition of accepting foreign payments to immediate family members of the president or vice president does just that. And I'd like to wish Emily the best, and Jessica the best. And I know it's so funny because I was actually going to compliment you for always getting my name right. I totally botched your name, so I'm so sorry about that. But good luck in everything, and thank you for always pronouncing my name. I yield back. Thanks, Mr. Chairman.
Mr. Chairman, if I may, just to speak in support of Mr. Fowler's amendment, this is absolutely critical. You have a situation where a presidential offspring is selling artwork to nobody knows who because it's completely obscured to the public. Could this be people who are actually foreign actors? We don't know, and that's the point. And that's why Mr. Eschenthaler's amendment is so critically important, because we have to stop an egregious process that is occurring even as we speak, and we have the opportunity to rein that in, and we should. So I thank the gentleman for the amendment, and I yield back.
Well, we certainly tried to rein it in the last administration with absolutely no help from anybody over.
So you admit
As I
it's
know, but
partisan.
while this amendment appears well-intentioned, the Constitution and the underlying legislation already prohibit immediate family members of office holders from accepting emoluments under certain circumstances. And adding this language would create a need for unnecessary legal debate of the meaning of the terms in POTA and the Constitution. So I would urge a no vote. So the vote is now on the Reschenthaler amendment. All those in favor say aye. Aye. Opposed, no. No. Being the chair, the noes have it.
Mr. Chairman, I ask for a recorded vote.
A recorded vote has been requested. Clerk will call the roll.
Mrs. Torres? Mr. Perlmutter? No. Mr. Perlmutter? No. Mr. Raskin?
No.
Mr. Raskin? No. Ms. Scanlon? No. Ms. Scanlon? No. Mr. Morelli? No. Mr. Morelli? No. Mr. DeSaulnier?
No.
Mr. DeSaulnier? No. Ms. Ross?
No.
Ms. Ross? No. Mr. Neguse? Mr. Neguse? No. Mr. Cole?
Aye.
Mr. Cole? Aye. Mr. Burgess? Aye. Mr. Burgess? Aye. Mr. Eschenthaler? Mr. Eschenthaler? Aye. Mrs. Fishbach? Mrs. Fishbach? Aye. Mr. Chairman?
No.
Mr. Chairman?
Clerk
No.
report the total.
4 yeas, 8 nays.
The amendment is not agreed to. Further amendments? Seeing none, then the question is now on the motion offered by the gentlewoman from Pennsylvania. All those in favor say aye. Aye. All the opposed say no. No. In the opinion of the chair, the ayes have it, and the motion is agreed to.
On that, Mr. Chairman, question.
The recorded vote has been requested. Clerk will call the roll.
Mrs. Torres? Mr. Perlmutter?
Yes.
Mr. Perlmutter? Aye. Mr. Raskin?
Aye.
Mr. Raskin? Aye. Ms. Scanlon? Ms. Scanlon? Aye. Mr. Morelli? Aye. Mr. Morelli? Aye. Mr. DeSaulnier?
Aye.
Mr. DeSaulnier? Aye. Ms. Ross?
Aye.
Ms. Ross? Aye. Mr. Neguse? Mr. Neguse? Aye. Mr. Cole?
Somebody has to stand up for Mr. Perlmutter. No.
Mr. Cole? No. Mr. Burgess? Mr. Burgess? No. Mr. Eschendaler? Mr. Eschendaler? No. Mrs. Fishbach? No. Mrs. Fishbach? No. Mr. Chairman?
Aye.
Mr. Chairman? Aye.
Clerk, report the total.
8 yeas, 4 nays.
The ayes have it, the motion is agreed to, and Ms. Scanlon will carry it for the Democrats.
And I will carry it for the Republicans, that's fine.
And it will be on the floor at 5:15. Without objections, the Rules Committee is adjourned. Thank you, everybody.